She thought the divorce would destroy her. She had no idea it would set her free. For 15 years, Claire Rowan lived inside a cage built from marble countertops and designer silence, married to a man who mistook her patience for weakness and her stillness for surrender. Nathan Cross stood at the top of Connecticut's real estate empire. A man who bought judges the way other men bought coffee, who measured people by what they could do for him and discarded them the moment they couldn't. He expected this divorce to be easy. He expected Claire to take the check, sign the papers, and disappear into the quiet life he'd always believed she deserved. He was about to learn what 15 years of watching and waiting actually looked like when it finally moved. If this story hits you, if you've ever underestimated someone standing right next to you, hit that like button and drop a comment with the city you're watching from. I want to see how far this story travels. Now let's get into it. What? Part 1. The Woman Who Said Nothing. The morning of the first hearing, Claire Rowan stood in the parking garage beneath the Hartford County Courthouse and threw up behind a concrete pillar. Not from fear. She told herself that, and mostly believed it. Her hands weren't shaking. Her pulse was elevated but controlled, the way it got before a difficult conversation or a long drive in bad weather. Not panic, just the body's honest accounting of what was at stake. She wiped her mouth with the back of her wrist, straightened, and looked down at the manila folders tucked under her arm. 18 months of work, 14 flash drives, 11 certified forensic accounting reports obtained through a contact her father had trusted 30 years ago and whose son now ran the same firm with the same precision. She pulled a mint from her coat pocket, crushed it between her teeth, and walked toward the elevator. The courtroom on the 4th floor of the Hartwell Judicial Complex was not large, but it had the kind of stillness that made small sounds carry. The heating system ticked. Someone in the gallery coughed. The flags on either side of the judge's bench hung perfectly motionless in the recycled air. Claire entered from the side corridor and took her seat at the plaintiff's table. Alone, no attorney beside her, nothing but her folders and a yellow legal pad, and felt the weight of 24 stares settle onto her back like something physical. Nathan was already seated at the defense table. He had brought 3 lawyers, which was 2 more than anyone needed for a divorce proceeding, and 1 more than the table comfortably held. His lead counsel, Gerald Voss, was 61, silver-haired, and wore his reputation the way certain men wore expensive watches, visibly, deliberately, designed to be noticed across a room. Voss had handled the divorces of 3 Connecticut governors, 2 hedge fund managers, and a professional athlete whose settlement had never been made public. He charged $400 an hour and was worth every cent of it, at least from where Nathan was sitting. Nathan himself looked exactly as he always looked, composed, faintly amused, dressed in a charcoal suit that cost more than Claire's first car. He was 53, with the kind of face that photographed well and aged gracefully and gave nothing away. He glanced at Claire when she sat down, and the corner of his mouth moved in something that wasn't quite a smile. She didn't look back at him. She uncapped her pen and wrote the date at the top of the legal pad in small, careful letters. The bailiff called the room to order. Judge Patricia Halverson entered from the side door, late 60s, reading glasses pushed up on her forehead, a woman with the particular weariness of someone who had seen too many people lie to her under oath to be easily surprised by anything. She settled into her chair, reviewed the docket, and looked up. "This is the matter of Rowan versus Cross," she said. "Divorce proceedings, no minor children, contested asset division." She looked at the plaintiff's table. "Miss Rowan, you're representing yourself?" "Yes, Your Honor." Halverson's expression didn't change, but something moved behind it. "You understand the complexity of contested asset proceedings?" "I do." "All right." She made a note. "Mr. Voss, opening statement, Benin." Voss stood with the ease of someone who had done this 10,000 times. His voice was smooth and precisely modulated, the voice of a man who had learned early that certainty, performed correctly, was its own form of evidence. He spoke about the Rowan-Cross marriage as a partnership between 2 adults who had grown apart, about Nathan's generosity in offering a settlement that exceeded what the law required, about the unfortunate reality that some people, when faced with the end of a long relationship, chose conflict over common sense. He used the word reasonable 7 times in 4 minutes. He referenced Claire's documented history of emotional instability, once, gently, as though reluctant to bring it up. Claire wrote the word reasonable on her legal pad with a small circle around it. When Voss sat down, Judge Halverson looked at the plaintiff's table. Ms. Rowan, opening statement. Claire stood. She was 44 years old, 5'6", with dark hair pulled back simply, and the kind of face that people tended not to remember at first, and then couldn't stop noticing once they'd actually looked at it. She was wearing a navy blazer over a white blouse, low heels, no jewelry except small gold earrings. She had dressed deliberately, had thought about it for 3 weeks, had considered and rejected the idea of looking more formidable, and decided instead to look exactly like what Nathan had always said she was: quiet, unremarkable, easily overlooked. She looked at the judge, not at Nathan, not at Voss, at Judge Halverson, whose hands were folded on the bench and whose eyes were patient and waiting. Your Honor, Claire said. Her voice was clear and carried without effort. My husband has spent 15 years teaching me that I'm not very smart. I spent the last 18 months finding out he was wrong. She heard Nathan exhale through his nose, a small sound, almost nothing. But she'd spent 15 years learning to read the small sounds. I intend to demonstrate, she continued, that Nathan Cross has fraudulently concealed approximately $78 million in marital assets through a network of offshore shell corporations, nominee ownership structures, and falsified transfer documents. I have certified financial records, forensic accounting reports, wire transfer confirmations, and notarized statements from 3 individuals with direct knowledge of the concealment scheme. She set a hand flat on the top folder. I also intend to demonstrate that at least one expert witness scheduled to testify on behalf of the defense was paid to provide false testimony, and that Mr. Cross has known about this since the arrangement was made. The gallery shifted. Someone in the back row leaned forward. One of the junior attorneys at the defense table looked sideways at Voss, who had not moved and whose face showed nothing except a slight tightening around the jaw. Nathan was still perfectly still, but his thumb was pressed flat against the table. Claire sat down. Judge Halverson looked at both tables for a long moment. Then she said, We'll take a 15-minute recess before proceeding to evidence. The moment the judge left the bench, the room came alive in the low-key way of a courtroom trying to pretend it wasn't buzzing. Claire kept her eyes on her legal pad and uncapped her pen again. She felt rather than heard Nathan move behind her. He'd stood. She could tell by the slight change in the room's air. By the way, Voss's voice dropped to something she wasn't supposed to hear. She heard it anyway. She's bluffing, Nathan said. Voss said something she couldn't make out. She's bluffing, Nathan repeated, softer. She doesn't have anything real. Claire wrote a single word on the legal pad and circled it the same way she'd circled reasonable. She wrote, watch. The beginning of the marriage had not been a lie exactly. Claire had thought about this a great deal over the past 18 months, alone in the 2-bedroom apartment she was renting on the east side of Hartford, sitting at the kitchen table with her father's old forensic accounting textbook spread out beside her laptop. She had thought about what the beginning had been, if not a lie, and the closest she'd come to an answer was this. It had been a performance that both of them believed in, for a while, for different reasons. She had met Nathan at 30. She was teaching art at a private secondary school in New Haven, watercolor, composition, the fundamentals of seeing, and had a small studio apartment and a habit of working late and a quiet life she'd built carefully after law school and the bar exam and the sudden, complete realization that she didn't want to be a lawyer. Her father had understood this better than anyone. He'd spent 30 years as a forensic accountant, had watched money do terrible things to people, and had raised Claire to trust her instincts over her ambitions. When she told him she was leaving law to teach, he said, Good. Watch what people do with their hands. She had been watching Nathan's hands the night they met, at a charity auction in New Haven that a colleague had dragged her to. He had bid on a landscape painting with the casual authority of a man who bought things not because he wanted them, but because he was accustomed to winning. His hands were steady, and his attention was absolute, and when he turned and found her watching him, he smiled with what she'd taken at the time for genuine warmth. He was interesting, in the early years. She meant this honestly, without bitterness. He was genuinely intelligent, a particular kind of intelligence that ran along the axis of strategy and leverage, that saw relationships as systems and systems as problems to be optimized. For a long time, she thought she was the exception to that, the person he chose not to strategize around, not because he couldn't, but because she mattered enough that he chose not to. She had been wrong about that. The first sign had been small, and she had missed it. The second sign she had recognized and explained away. By the time the pattern became undeniable, they had been married 6 years, and she had given up her teaching position to manage the charitable foundation he'd established as a tax instrument, and her law degree had become a line on a resume no one ever asked about, and her studio time had become something she did on occasional Sunday mornings when the house was quiet. She had not been unhappy, precisely. She had been diminished. Which was different, and in some ways worse, because diminishment was gradual enough that you could tell yourself it wasn't happening while it was happening. The moment she started to fight back was not dramatic. It was a Tuesday in November 2 years ago, and she was reviewing documents for the foundation's annual filing when she noticed a transfer. $40,000 moved from a foundation account to an LLC she didn't recognize. She pulled the LLC's registration. It was incorporated in Delaware, nominee directors, no clear operational history. She looked for the counterpart transfer and didn't find it. She looked for the receiving account, and it bounced to a second entity registered in the Cayman Islands. She sat with that for 3 days. Then she called her father's old colleague, a forensic accountant named Robert Delaney, whose son Marcus now ran the firm. "I need you to look at something," she said. Quietly. Marcus Delaney was 42 and meticulous and had the flat effect of someone who had spent his career converting outrage into spreadsheet notation. He looked at the transfer and called her back in 4 days. "Claire," he said, "how long has your husband been doing this?" "I don't know yet." "We need to find out." What followed was 14 months of structured, patient, invisible work. Claire handled the foundation's quarterly reviews herself, which gave her legitimate access to a substantial portion of the financial documentation. Marcus built out the methodology. Together they traced the network backward, one LLC to the next, one nominee director to the offshore account behind him, one falsified document to the wire transfer that revealed the real one. The full picture emerged slowly and then all at once, the way a photograph develops in a darkroom. First the outlines, then the details, then the complete image that you can't unsee. $78 million, 23 shell entities across 5 jurisdictions, payments to 3 public officials, a falsified property appraisal filed with the Connecticut Department of Revenue, and a pattern, deliberate, designed, of keeping Claire's name entirely off the legitimate assets while quietly attaching it to the liabilities. She had filed for divorce the following March. She had not told Nathan why. She had simply handed him the papers and watched his face go through the calculation she knew it would. Easy, quick, over in 3 weeks with a minimal payout. He would have his attorneys offer her the vacation house in Maine, a lump sum settlement of around $2 million, and a non-disclosure agreement. She would sign. She would disappear, and the offshore empire would continue without interruption. She had watched his face do all of that and said nothing. And then she had gone to her car and driven to Marcus Delaney's office and spent the next 6 weeks building the presentation she would use in court. When the recess ended and Judge Halverson retook the bench, Claire presented her first set of documents. She walked through them methodically, without drama, Exhibit A through Exhibit F in the first hour alone, each document authenticated, each connection explained in plain language that required no legal expertise to follow. She had spent 3 months practicing the explanations with Marcus, who had the useful habit of stopping her whenever she used jargon and making her say it differently, in the language of someone describing something they'd actually seen. She explained the Delaware LLC. She explained the Cayman account. She explained how money moved between the two and where it went from there, which was into a real estate acquisition fund registered in Luxembourg that Nathan controlled through a nominee director named Thomas Reyes, who was, she noted, employed as a groundskeeper at Nathan's Greenwich property under a separate payroll. Voss objected 17 times in 2 hours. Halverson sustained 4 of them. Nathan sat at the defense table with his arms folded and his face arranged in an expression of calm that Claire recognized as the face he wore when he was determining whether a situation could still be managed. She had seen that face many times. She had learned, too late and then not too late, that the face was a decision mechanism, that behind it he was calculating not whether he was guilty, but whether the evidence was enough to matter. She had watched him run that calculation in contract negotiations, in dinner conversations, in the cold-lit aftermath of arguments that she'd thought were about something and he'd already decided were about leverage. She kept presenting documents. At 12:40, Halverson called the lunch recess. Nathan caught her at the corridor door 3 steps ahead of Voss, moving fast and quiet. His hand didn't touch her. He'd learned years ago that she flinched at unexpected contact and had used that knowledge strategically for most of their marriage and wasn't using it now, which meant he was being careful. "Where did you get those documents?" he said. His voice was low and controlled. She looked at him directly. "From the documents." "That's not an answer." "It's the only one you're getting." Voss appeared at Nathan's shoulder. "Mr. Cross." A hand, brief, on Nathan's arm. "Not here." Nathan held her gaze for 3 seconds. His eyes were pale gray and very still, the eyes of a man who had never in his life been surprised by anything and was working hard to maintain that record. "You don't know what you're doing," he said. Claire thought about the Tuesday in November, the $40,000 transfer, the way the spreadsheet had opened on her laptop like a door into a room she'd been locked out of for years. "No," she said. "I know exactly what I'm doing." She walked away down the corridor, her heels quiet on the marble, the folders under her arm, the yellow legal pad in her hand with its careful handwriting and its circled words. Behind her, she heard Nathan say something sharp and quiet to Voss, and Voss say something back in his professional managing tone, and then the sound of the courtroom door opening and closing. She made it to the women's restroom at the end of the corridor before her hands started shaking. She stood over the sink and let them, running cold water over her wrists until the shaking passed. Her reflection in the mirror looked back at her, dark eyes, set jaw, the beginning of something in her face that she hadn't seen there in a long time, and almost didn't recognize. She recognized it now. It was not triumph, it was too early for that, and she was too careful a person to confuse momentum with victory. It was something more fundamental, something that felt like the moment when you've been holding your breath for a very long time and you finally let it go. She dried her hands, straightened her blazer, and went to find something to eat before the afternoon session. The afternoon brought Voss's first significant move, and she had expected it, but expecting something and experiencing it were different things. Voss called Dr. Edmund Farr to testify. Farr was a psychiatrist with a practice in Westport and a list of expert witness credits that Voss laid out slowly, for effect. 14 years of courtroom testimony, hospital board appointments, a teaching position at a medical school in Boston. He was 60-something, with a white beard and wire-rimmed glasses, and the unhurried manner of a man accustomed to being the most credentialed person in any given room. Voss walked him through a series of observations about Claire's documented emotional history. There had been an incident 3 years ago, a car accident, minor, Claire's fault, which had led to a referral to a therapist she'd seen for 8 sessions, and then stopped seeing because the therapist was Nathan's therapist's colleague, and she'd recognized the conflict of interest too late. Farr characterized this as evidence of treatment-resistant emotional dysregulation. There had been a hospitalization 2 years ago. One night, exhaustion, a low-grade fever that had spiked during a foundation gala and required observation, which Farr characterized as a stress-related episode consistent with chronic anxiety disorder. He spoke carefully and at length, using the vocabulary of diagnosis the way a craftsman used a tool, with precision and with purpose. The gallery listened. The jury was not there. This was a divorce proceeding, no jury. But the gallery listened, and Halverson listened, and Claire sat at her table and wrote down every specific claim Farr made on her legal pad with the same careful handwriting she'd been using all morning. When Voss finished, Halverson looked at the plaintiff's table. "Miss Rowan." Cross-examination. Claire stood. She looked at Farr for a moment without speaking. He met her eyes pleasantly and waited with the patience of someone who had been cross-examined before and found it largely unremarkable. "Dr. Farr," she said, "did you conduct any direct clinical evaluation of me?" "I reviewed your medical documentation." "Did you conduct any direct clinical evaluation of me?" she repeated. "In person, face-to-face." "My assessment was based on, yes or no, doctor." A pause. "No." "Did you speak with the therapist who treated me?" "I reviewed her notes." "Did you speak with her?" "No." Claire reached into the second folder and removed a single sheet of paper, which she handed to the bailiff to pass forward. "I'd like to introduce Plaintiff's Exhibit G," she said. A transcript of a recorded telephone conversation between Dr. Edmund Farr and a paralegal employed by Voss, Klein, and Hartley, dated 6 weeks ago. The room went still in a specific way. Not the rustling stillness of a pause, the charged stillness of a space where something unexpected has happened and no one has yet decided what it means. Voss was on his feet. "Objection, Your Honor." "On what grounds, Mr. Voss?" "A beat. Authentication." The transcript includes a digital timestamp, a certification from the recording platform, and a notarized statement from the individual who obtained the recording, Claire said, all of which are attached as supporting documentation. Halverson looked at Voss. Voss looked at the transcript. Something moved across his face, fast, controlled, but there. He sat down. "I'll allow it," Halverson said. "Continue." Claire looked at Farr, whose pleasant expression had become something else. Not afraid, but recalculating. She recognized the expression. She'd spent 15 years watching it on another face. "Dr. Farr," she said, "in this recording, you tell the paralegal that you have, and I'm quoting your exact words, reviewed the relevant materials and can characterize the subject's history in whatever terms are most useful for the defense's purposes. Is that an accurate description of your typical approach to expert witness work?" The silence that followed was its own kind of answer, but it was what came next, what she had held back until this moment, the details she had saved because timing was everything, and she had learned timing from watching a man who believed he had all of it. That made even Judge Halverson set down her pen, because on page 3 of the transcript, recorded in the same digital timestamp and certified by the same notary, was the amount. The specific, itemized, agreed-upon amount that had changed hands between Dr. Edmund Farr and the law firm of Voss, Klein, and Hartley, in exchange for testimony that would establish Claire Rowan as mentally unfit to manage her own legal affairs. $40,000. The same number that had started everything on a Tuesday in November, in a foundation document on her laptop, the $40,000 transfer she had almost missed, the first thread she had pulled, the one that had unraveled all of it. She stood at the plaintiff's table in the Hartford County Courthouse, folders under her arm, legal pad in hand, and let the number sit in the air of the room for exactly as long as it needed to. "No further questions," she said, and sat down. Nathan didn't look at her when the session ended. He walked out with Voss and the 2 junior attorneys, moving fast, and she heard their voices drop into something clipped and urgent as soon as the courtroom doors swung shut behind them. She packed her folders slowly. The gallery emptied around her. A court reporter gathered her equipment. The bailiff dimmed the lights near the back. Halverson paused at the bench, already in her coat, and looked at the plaintiff's table with an expression Claire couldn't entirely read, part assessment, part something more complicated. "We resume tomorrow at 9, Halverson said. "Ms. Rowan, you'll want to eat something tonight." It was a strange thing to say, and Claire turned it over on the drive home through the dark Connecticut evening, the dashboard lights soft and the road wet with recent rain. "You'll want to eat something tonight." The advice of someone who had watched too many people spend the night of a good day forgetting to take care of themselves. She stopped at a diner near her apartment, ate a grilled cheese sandwich and a cup of black coffee at the counter, alone, with the yellow legal pad open in front of her, the new notes for tomorrow's session written out in careful rows. She was 3 pages into the notes when her phone buzzed on the counter. Unknown number, text message, 4 words. "You should stop now." She stared at it. Then she turned the phone face down on the counter, finished her coffee, and went back to the notes. She had 11 more exhibits to present. She had a chain of transfers that connected Nathan's Luxembourg fund to a construction project that Halverson hadn't heard about yet. A project that was going to change what this case was about, fundamentally and completely, in a way that not even Nathan's lawyers were prepared for. And she had, filed in a sealed envelope in the second drawer of her kitchen table at home. The document she had not used yet, the one she was saving for the moment when Nathan believed he still had a way out. Outside the diner window, Hartford moved through its ordinary Tuesday night. Headlights, pedestrians, the ordinary low hum of a city that didn't know what was happening in a courtroom on its 4th floor and wouldn't until tomorrow morning when the newspapers ran it. She watched the street for a while, her reflection pale in the glass, the coffee cup warm between her hands. She thought about the text. You should stop now. She thought about the $40,000 transfer, the Tuesday in November. 14 months of work laid out in folders on a kitchen table, slowly, patiently, in the language of numbers that didn't lie. She thought about Nathan's face when she'd read the amount from page 3 of the transcript. The first time in 15 years she had watched him fail to manage his expression fast enough. She paid the check, walked to her car in the light rain, drove home. She did not stop. The text was still on her phone when she woke at 5:15 the next morning. You should stop now. She read it again in the gray pre-dawn light coming through the bedroom window, lying on her back with the phone held above her face, and felt the same thing she'd felt at the diner counter the night before. Not fear, exactly, but a low, careful awareness. The way you feel when you realize the weather has changed while you were inside and now you have to account for it. She screenshot the message, emailed it to Marcus Delaney with a note that said, "Keep this," then set the phone face down on the nightstand and got up. She showered, made coffee, ate toast standing at the kitchen counter, reviewing the notes for the morning session while the city outside her window came slowly awake. Garbage truck, distant traffic, the particular gray light of a Connecticut November that never fully committed to being bright. She had 6 new exhibits to introduce before noon. She had a witness she intended to call in the afternoon, a former bookkeeper named Patricia Holt, who had worked for one of Nathan's holding companies for 3 years before being let go, quietly and with a generous severance, in circumstances that had everything to do with what she knew and nothing to do with her performance. Patricia Holt had called Claire 7 months ago, not the other way around. Claire thought about that as she gathered her folders in her coat. Patricia Holt had watched the divorce filing appear in the public record and had called the plaintiff's number listed on the court documents and said simply, "I think I can help you, if you can protect me." Claire had spent 6 weeks arranging the protection, a formal agreement with the state attorney's office, brokered through a contact she'd maintained from her law school years, a woman named Diane Chu, who now worked in the Financial Crimes Division and who had reviewed Claire's evidence 3 months ago in a meeting that lasted 4 hours and ended with Diane looking at the ceiling and saying, very quietly, "This is not just a divorce, Claire." She knew that. She had known it since the Luxembourg Fund. She put on her coat, picked up her folders, and drove to the courthouse in the dark. Nathan arrived at 9:03, which was 2 minutes later than the previous day and meant something, though she wasn't sure yet what. He looked the same, composed, expensive, calibrated, but his left hand, when he set his briefcase on the defense table, opened and closed once against the leather surface before he caught it and stopped. Voss did not make eye contact with her. Judge Halverson took the bench at 9:15 and looked at both tables with the expression of someone who had read the morning news and found it informative. "Before we proceed," Halverson said, "I want to note for the record that this court has received, as of 8 o'clock this morning, a courtesy notification from the Connecticut Financial Crimes Task Force indicating that they are monitoring these proceedings in an advisory capacity." She paused. "Mr. Voss, any comment from the defense?" Voss stood. "Your Honor, the defense reserves the right to—" "That wasn't a question requiring a legal response," Halverson said. "I was informing you. Sit down." Voss sat down. One of the junior attorneys wrote something on a notepad and slid it sideways toward him. Voss read it without moving his head. Claire uncapped her pen. She began with Exhibit H, a series of wire transfer records pulled from a Swiss banking institution through an international mutual legal assistance request that Marcus had helped her draft and that Diane Chu's office had formally submitted. The transfers moved in increments of just under $10,000 each, the classic structuring pattern designed to stay beneath federal reporting thresholds. 41 transfers over 22 months, each one landing in the account of a nominee director named Robert Keene, who was, as Claire explained to the court with the same flat, methodical clarity she had used the day before, not a real person. "Robert Keene," she said, "is a constructed identity using the Social Security number of a deceased individual from Bridgeport, Connecticut, who passed away in 2009. She handed the bailiff the next exhibit. His Connecticut driver's license, shown here as Exhibit 1, was issued in 2016 using a forged birth certificate. The photograph on the license is that of Thomas Reyes, the same individual I identified yesterday as the nominee director of the Luxembourg Acquisition Fund, employed at my husband's Greenwich property as a groundskeeper. The gallery had gone fully silent. Not the polite silence of people watching testimony, the caught breath silence of people processing something that was larger than they'd expected when they walked into the room. At the defense table, Nathan's hand had gone flat on the surface again, completely still this time. Voss rose for an objection, and Halverson waved it down before he finished the first word. The break at 10:30 was 15 minutes, and Nathan used 12 of them to corner Voss in the corridor outside the courtroom. Claire knew this because she could hear them through the door, which had not latched properly, and because she had learned in 15 years of marriage to read the tenor of Nathan's silences as well as his speech, and the silence between his sentences in that corridor was the silence of a man rewriting his understanding of his own situation. She sat at the plaintiff's table and reviewed her notes and did not move toward the door. "Not possible," Nathan was saying. "Those accounts were sealed. The nominee structure was clearly it wasn't sealed enough." Voss's voice, still professional but with a new texture in it, something tight, something that had not been there yesterday. She had help. She had to have had help. Someone from inside. Nathan. Flat, quiet. It doesn't matter how she got it. It's authenticated. It's in front of the judge. What matters now is what's coming next, and we need to know what that is before she introduces it. A silence. "I want you to find out who she's calling this afternoon," Nathan said. "I want a name." "We'll know when she calls them." "That's too late." "That is where we are." The door drifted slightly further open on its bad hinge, and Claire heard footsteps, Voss moving away, the tap of his shoes on the marble deliberate and measured. Then Nathan, not moving, standing there. She kept her eyes on the legal pad. After a moment, she heard him come back into the courtroom. She felt him stop behind her, not close, but close enough that she was aware of the exact distance between them, 3 feet, maybe 4, and the quality of the air in that distance, which was dense with something she hadn't felt from him in years. It was not anger. She knew his anger well, its texture and temperature. This was something Nathan Cross almost never produced, because he almost never had reason to. It was uncertainty. Claire, his voice was very low, just her name. She finished writing the sentence she was on, set the pen down, did not turn around. "Whatever you think you're doing," he said, "you're not prepared for what happens after. You understand that? You think this ends with you winning a divorce." She turned then, looked at him straight. He was standing with his suit jacket still perfectly pressed and his hands loose at his sides and his face arranged in something that was meant to look like concern and didn't quite. "It ends," she said. "When it ends." He held her gaze for 2 seconds. 3. Then he walked back to the defense table and sat down and did not look at her again for the remainder of the morning. Hotess. Patricia Holt was 56 years old, with the compact, braced posture of someone who had spent years waiting for something bad to happen and had developed good muscle memory around the waiting. She wore a gray blazer and kept her hands folded in her lap on the witness stand, and when she looked at Nathan Cross, she did it the way you look at something you've assessed fully and decided to stop being afraid of. Claire liked her immediately, in the specific way she liked people who had made a hard decision and were still standing after it. "Miss Holt," Claire said, "you were employed by Crossfield Asset Management from 2018 through 2021? "I was." "In what capacity?" "Senior bookkeeper. I handled accounts payable and receivable for 7 of the holding entities under the Crossfield umbrella." "And during that employment, did you observe financial transactions that you considered unusual?" Patricia Holt's hands tightened briefly in her lap, and then relaxed. "I observed transactions that I considered fraudulent," she said. "I used the word unusual at the time because I was afraid to use the correct word." Voss objected. Halverson overruled it. "Can you describe the transactions?" What followed was 40 minutes of testimony that Claire had rehearsed with Patricia 11 times over the past 4 months. Not to shape it, Patricia knew what she knew and said it plainly. But to help Patricia say it in the sequence that built the picture most clearly, each detail locking into the next the way her father had described good forensic work. Not a story you're telling, Claire, a structure you're revealing. The story was always there. You're just removing what was built around it to hide it. Patricia described payments to contractors who did not exist. She described invoices for materials on properties that had never broken ground. She described an instruction she'd received, verbally, from a man she knew only as Daniel from the main office, to reclassify a series of liability entries as operational expenses, which she had refused to do, and which had resulted, 3 weeks later, in her termination for performance deficiencies that she had never previously been informed of. "Did you report these concerns to anyone at the time?" Claire asked. "I tried." Patricia's voice was steady. "I contacted the compliance officer at Crossfield. I was told the transactions had been reviewed and approved at the executive level." "Did you pursue it further?" "I contacted an attorney. I was told that the severance agreement I'd signed included a non-disclosure clause and that pursuing a complaint could expose me to legal liability." "Were you advised of any exceptions to that clause?" "No." A beat. "I didn't know at the time that non-disclosure agreements can't legally prevent reporting fraud to a regulatory authority." Voss was on his feet. "Objection, Your Honor. Legal conclusion." "I'll rephrase," Claire said. "Ms. Holt, did anyone inform you that you had the right to report suspected fraud to the State Financial Crimes Division regardless of your severance agreement?" "No, no one told me that." "And had you known that, would you have reported it sooner?" Patricia Holt looked at Claire. Her eyes were dry and direct and held something in them that wasn't grief and wasn't anger, but was somewhere between the two. The specific expression of someone who has spent years carrying something they should have been able to put down. "Yes," she said. "A lot sooner." Sean. The afternoon break came at 3, and the energy in the room had changed again, thickened, the way air thickens before a storm. Everyone in the gallery feeling the pressure shift without being able to name exactly when it had happened. Claire went to the women's restroom and stood over the sink and breathed for 90 seconds, and then looked at herself in the mirror and said quietly, the way her father used to say it before a difficult conversation, "Stay on the structure." She was on Exhibit N. She had, through Exhibit S, prepared. The Luxembourg Fund documents were Exhibit Q. She needed to get to Q before Voss found a procedural mechanism to adjourn for the day, because Halverson would allow him one more adjournment request before she stopped granting them, and Claire needed Q in front of the judge before that happened. She knew Voss would try something in the next session. He had too little left to work with in terms of offense and would shift to delay, challenges to authentication, motions for additional time to review documents, possibly an attempt to have her declared unfit to continue self-representation based on Farr's discredited testimony. She had prepared responses to all three. What she had not fully prepared for was what she found when she came back out of the restroom and nearly walked into a woman standing in the corridor facing the courtroom door, arms crossed, wearing a dark coat that was not quite warm enough for November. The woman was young, early 30s, with auburn hair pulled back and the kind of face that had been recently crying and was working hard not to show it. She was pregnant. Not significantly, maybe 5 or 6 months, but clearly. She looked at Claire with an expression that was difficult to read, not hostile, not afraid, but layered in a way that suggested she had been standing in this corridor for a while, deciding something. Claire stopped. The woman said, "You're her, Nathan's wife." "I am." "I'm Lena Brooks." The name registered. Claire had the name in her files. She had a lot of names in her files. But Lena Brooks was one she had circled in a different color, set aside, marked as unknown involvement, because she had found the connection, but not the shape of it. A lease on a Stamford apartment paid through a Crossfield subsidiary, payments to the same lease account that continued through the current month. The financial signature of Nathan keeping someone comfortable and accessible, and Claire had suspected controlled. She looked at Lena Brooks in the corridor outside Courtroom 4B and felt the situation rearrange itself around a new axis. "All right," Claire said carefully. "What do you want to tell me?" Ian. She asked for a 20-minute extension at the start of the afternoon session, citing a need to review a document with relevance to upcoming testimony. Halverson granted it without comment, in the tone of a judge who had decided this proceeding was going to run as long as it needed to and was making peace with that. Voss requested to know the nature of the document. Halverson told him he'd find out when the plaintiff introduced it. Claire used 15 of the 20 minutes in a conference room on the second floor with Lena Brooks and a voice recorder she'd bought 3 months ago in anticipation of exactly this kind of unscheduled development. Lena talked fast and without preamble, the way people talk when they've been holding something back long enough that release has its own momentum. She had met Nathan 2 years ago at a Crossfield client event. She had understood, she said, and she said it without apology, that she was not the only person in his life. She had not cared about that, or she had told herself she didn't care, which she now understood was different. What she had not understood until 4 weeks ago was the email. "What email?" Claire said. Lena opened her phone and showed her. It was between Nathan and Voss, forwarded to a third address that Claire didn't recognize and which Lena explained had been set up on Nathan's tablet, which Lena had access to because Nathan had given her the passcode 18 months ago and never thought to revoke it. The email was dated 3 months ago. It was 11 lines long. It discussed, in the careful, slightly abstract language of men who believed they were being discreet, the upcoming divorce proceedings, the anticipated settlement timeline, and the necessity of ensuring that the secondary exposure, Lena's name appeared in the next line, without ambiguity, was managed in a manner that transferred liability appropriately before the proceedings concluded. The phrase transferred liability appeared twice. Claire read the email twice. She kept her face still. "He was going to set you up," she said, "for the embezzlement." Lena's jaw tightened. "The Crossfield account I've been receiving payments from, the Stamford lease, the monthly deposit, it's all under an entity he told me was a personal trust. He said it was so his name wouldn't appear directly." I believed him. She stopped, breathed. "I was stupid." "You were lied to." "I was stupid," Lena said again, with a finality that didn't want to be argued with. Claire looked at the email again. She thought about the sealed envelope in the second drawer of her kitchen table, the document she had been saving. She thought about timing and structure and her father saying, remove what was built around it to hide it. "Can you forward me this email chain?" she said. "Already sent it to the address on your court documents." Claire looked at her. "You prepared for this conversation." "I've been standing in that corridor for an hour and a half," Lena said. "I had time to think." The afternoon session produced Exhibits N through Q in 3 hours of testimony, cross-examination, and sustained objections that Halverson batted down with increasing impatience. Exhibit Q, the Luxembourg Fund documentation, landed in front of the judge at 4:55, 40 minutes before the scheduled close of session, and Claire walked through it in the methodical, structural way she had practiced until the sequence lived in her body, not just her notes. The fund had been established in 2017. It controlled a 40% interest in a real estate development project called Meridian Tower, a 42-story luxury residential skyscraper currently under construction in downtown Hartford, valued at $1.1 billion, scheduled for completion in 18 months. Nathan Cross was not listed as a principal on any Meridian Tower documentation. He appeared nowhere in the official corporate structure. His name was on no permits, no financing agreements, no contractor relationships. He controlled the fund that controlled the interest through Robert Keene, who did not exist, through Thomas Reyes, who was his groundskeeper. Claire let the judge review the fund documentation in silence for 4 minutes. Then she said quietly, "Your Honor, I would also like to note that the plaintiff has become aware of additional documentation relating to the Meridian Tower project that has not yet been introduced as evidence, but which I intend to present in tomorrow's session. This documentation relates to the structural certification of the building and to certain representations made to the Hartford Building Authority." The room went still in the specific, different way it went still when something new entered the air, something whose shape wasn't yet clear, but whose weight was already felt. Voss said, "Your Honor, the defense would request an adjournment to allow time to—" "Denied," Halverson said. She hadn't looked up from the Luxembourg documents. Nathan, at the defense table, finally turned and looked at Claire. It was the first direct look he'd given her in 3 hours, and it was not the look of a man calculating whether the situation could still be managed. It was the look of a man who had just realized it couldn't. Claire gathered her folders and her legal pad, capped her pen, and began organizing her exhibits for the morning. Her phone was in her coat pocket. She had turned it to silent before the session began. She checked it now, under the table, and found 3 missed calls from the same unknown number that had sent the text the night before. No voicemail, no new message. She put the phone back in her pocket and continued organizing. Tomorrow she was going to introduce Exhibit R, the engineering survey she had commissioned 4 months ago, conducted by a licensed structural engineer named Harold Briggs, who had spent 12 years at the Connecticut Department of Buildings before going private. Harold Briggs had reviewed the Meridian Tower site documentation and produced a 94-page report whose executive summary contained the following sentence, which Claire had read so many times in the past 4 months that she could reproduce it from memory without looking at the page. The foundation design, as approved and implemented, is structurally inadequate for the load-bearing requirements of the proposed structure, and the safety certifications filed with the Hartford Building Authority do not accurately reflect the results of the independent soil analysis conducted prior to construction. Someone had known the building was unsafe. Someone had bribed the inspectors anyway. Someone had filed false safety certifications with the city. And someone, the same someone whose name was on no document, who existed in this story only as a groundskeeper and a dead man's social security number, had arranged for Claire Rowan's forged signature to appear on the liability transfer documents that would make her legally responsible if the building came down. She had discovered this 4 months ago and had not slept a full night since. She closed the last folder. Around her, the courtroom was emptying, gallery, attorneys, bailiff moving toward the door. Halverson had left the bench. The flag stood motionless in the recycled air. Nathan was the last to leave. She heard his chair push back, heard his briefcase close, heard the even unhurried sound of his footsteps moving toward the door. He didn't speak. He didn't stop. But at the door he paused, just a fraction of a second, the smallest hesitation. And in the quality of that pause, she read something she had been waiting 15 years to hear from him and never expected to hear this way. He was afraid. She sat alone in the empty courtroom for 2 minutes after he left, hands flat on the table, breathing slowly. Then she picked up her folders and walked out into the corridor, which was empty now, the marble floor reflecting the overhead lights in long, pale strips. Marcus Delaney called as she reached the elevator. "I got the email from Lena Brooks," he said without preamble. "I know." "Claire." His voice had something in it she hadn't heard before, even through 14 months of forensic accounting and wire transfer records and offshore shell entities. "The liability transfer document, the one with your forged signature." "Yes. I cross-referenced the notary stamp on it tonight. The notary whose seal is on that document. She notarized 41 other documents for Crossfield entities over the past 3 years. 41. All of them for transactions connected to the Luxembourg Fund." "Okay." "Claire, she notarized a document dated last month, after you filed for divorce, after the proceedings started." He stopped. "It's a property transfer, the Meridian Tower liability package. It transfers full legal responsibility for any structural failure, any deaths, any injuries, any litigation, to the entity whose representative signed off on the building authority certification." The elevator arrived. She didn't get in. "And whose signature is on that certification?" she said. Marcus was quiet for exactly the 3 seconds it took her to already know the answer. "Yours," he said. She stood in the corridor of the Hartford County Courthouse, folders under her arm, the elevator waiting with its doors open, the fluorescent light overhead buzzing faintly against the silence, and understood with complete cold clarity that what she had walked into this building to win was no longer a divorce. It never had been. She didn't sleep. She tried. She lay down at 11:30 with the lights off and her phone on the nightstand and the folders stacked on the kitchen table exactly as she'd left them, and she stared at the ceiling for 40 minutes while her mind ran the same sequence on repeat. The notary stamp, the 41 documents, the liability transfer, her name on a certification she had never seen and never signed. And then she got up, made coffee, and sat at the kitchen table until 3 in the morning going through everything again from the beginning. Not from panic. She needed to be precise about that. Needed to keep the distinction clean inside herself, the way you keep a blade clean. because panic and precision couldn't occupy the same space, and she needed precision more than she had ever needed it in her life. She was going through it again because something in the sequence didn't fit, and the thing that didn't fit was timing. The property transfer document Marcus had found, the one that placed full structural liability for Meridian Tower on the entity whose representative had signed the building authority certification, was dated last month, 3 weeks after she filed for divorce, after the proceedings were public record, after Nathan knew she was coming at him in court, which meant it wasn't insurance. It wasn't a contingency plan he'd built into the original scheme. It was a response to her. She sat with that understanding for a long time. The coffee went cold. The kitchen was very quiet. Outside, a car passed on the wet street, headlights sliding briefly across the ceiling, and she watched the light move and thought about what it meant that Nathan had constructed her as a scapegoat, not at the beginning of the fraud, not as a cautious backstop in case something went wrong, but specifically and recently, after she had showed her hand. He knew she had evidence. He didn't know how much, or he hadn't known. She had disclosed only the initial filing documents to his attorneys, had held back the core forensic work until the courtroom, but he had known enough to build a new trap. A trap constructed not from what he'd done in the past, but from what he knew she was doing right now, which meant someone had told him. Someone who knew enough about her case to understand what documents mattered and where she was in the preparation. She opened her laptop, went back through her email from the past 6 months, slowly, looking not for anything specific but for the shape of things, who she had contacted, when, what she had said. Marcus Delaney, Diane Chu, her former law school colleague, a man named Peter Vargas who had helped her with the international legal assistance request, Patricia Holt, a paralegal she'd hired briefly in August to help organize document production, a young woman named Sarah Novak, who had worked 12 days and then told Claire she'd taken a full-time position elsewhere. She stopped at Sarah Novak. She sat very still for a moment. Then she opened a new browser window and typed Sarah Novak's name into a professional directory search. The result came back in 11 seconds. Sarah Novak. Current position? Paralegal, Voss, Klein, and Hartley. Start date, September of the current year. 3 weeks after she'd stopped working for Claire. Claire closed the laptop, set both hands flat on the table, breathed in through her nose, slow and controlled, 4 counts, the way her therapist had taught her in the 8 sessions she'd had before she recognized the conflict of interest, the only useful thing those sessions had produced. Sarah Novak had spent 12 days in Claire's workspace. She had seen the document organization system. She had seen the exhibit list, the folder structure, the chain of forensic accounting reports. She had not seen the sealed envelope. Claire had never brought it to the shared workspace, but she had seen enough to understand the shape of the case, enough to tell Voss where Claire was going and how far along she was, enough for Nathan to know he needed a new contingency, fast, and to construct one using the only instrument readily available. Her name, her forged signature. The legal architecture of her own destruction, built in the 6 weeks after Sarah Novak walked out of her workspace and into Gerald Voss's office. Claire put the kettle on and made fresh coffee and went back to the folders. There was a way through this. She needed to find it before 9 in the morning. She found it at 4:47, in a document she had already seen but had not looked at closely enough, a supplemental filing from the Hartford Building Authority that was part of the Meridian Tower permit record, publicly available, that she had pulled 3 months ago and cataloged as background context without fully examining its contents. The document was a record of the Building Authority inspection schedule, routine, administrative, the kind of paperwork that lived in public databases and accumulated without anyone paying much attention to it. She had run her eyes over it briefly in August and moved on. She read it carefully now. The final structural certification for Meridian Tower's foundation phase, the one bearing what was allegedly her signature, the one that approved the inadequate foundation design identified in Harold Briggs's engineering report, had been filed on a Tuesday in March of the previous year. On the Tuesday in March of the previous year, Claire had been in Portland, Maine, at the vacation house Nathan had offered her in the divorce settlement, which he owned and which she had driven to alone, on impulse, because she had needed 2 days away from the kitchen table and the spreadsheets and the growing weight of what she was uncovering. She had used her credit card at a gas station in New Haven on the way up, at a restaurant in Portland that evening, at a grocery store the following morning. She had called her father from the house landline twice. She was 300 miles away when her signature appeared on a document in Hartford. She had an alibi she hadn't known she needed. She called Marcus at 6. He picked up on the second ring, which meant he hadn't been sleeping either, and she didn't remark on it. "I need the Meridian Tower permit filing, the structural certification from March of last year." "I have it." "Pull the signatory line. The exact form of the signature." She heard him typing. A pause. "It's a typed signature block, Claire A. Rowan, authorized representative, Crossfield Development Partners, LLC," followed by what appears to be a wet signature scan. "Is there a notary acknowledgement?" "Yes. Same notary as the liability transfer. Margaret Ewan, Stamford." "Margaret Ewan notarized a signature I wasn't present to give," Claire said, which means she either forged the acknowledgement or was given a pre-signed document and fraudulently certified it without witnessing the signature. A silence on the line. "Either way," Marcus said slowly, "that's criminal notary fraud. That's a separate felony from the building certification fraud." "I know." "Claire, if you put Margaret Ewan on the stand—" "I'm not putting her on the stand. I'm giving her documentation to Diane Chu and letting the Financial Crimes Division decide what to do with her." She paused. "But I need her on record first, today, if possible, before the morning session." "It's 6 in the morning. I know what time it is." She heard him exhale. Not exasperated, just the sound of a man who had spent 14 months doing careful, patient work and was now watching it move very fast. "I'll call Diane at 7, he said. "She owes me one." "She owes both of us several." She hung up, went back to the table, picked up the sealed envelope from the second drawer, the one she'd been saving, the document she hadn't used yet, and held it in both hands for a moment without opening it. She had found this document 11 months ago and had held it back with the specific discipline of someone who understood that the most powerful piece of evidence you have is the one your opponent doesn't know exists. She had built the entire case around it without ever referencing it directly, had constructed every exhibit, every witness, every sequence of revelation as an approach to this moment, the moment when Nathan had run out of moves and believed himself cornered but not finished. She set the envelope on top of the folders. Today was going to be different from the previous 2 days. She felt the difference in her body, not the controlled elevation of the first morning, not the careful momentum of the second afternoon. Something harder, something that had less patience in it. The courtroom at 9 felt different, and she wasn't the only one who felt it. The gallery was fuller. Word had spread, she supposed, the way word spread in a city about a proceeding that had stopped being routine. And the atmosphere had the particular charged quality of a room where people had come expecting to watch something and were uncertain whether that made them participants or witnesses. Lena Brooks was in the gallery, third row, end seat, dark coat. She caught Claire's eye as Claire came through the door and gave a small, precise nod. Claire nodded back and sat down. Nathan arrived with Voss and both junior attorneys and a fourth person she hadn't seen before. A man in his 50s with a look that she placed immediately as outside counsel, brought in overnight, which told her that the previous evening had not been comfortable in the Voss, Klein, and Hartley offices. Good. Halverson took the bench at 9:12 and looked at both tables with an expression that had subtly shifted overnight. Less judicial patience, more deliberate attention, the face of a woman who had gone home the previous evening and thought carefully about what was in front of her and returned this morning with a different posture about it. "Before the plaintiff continues with evidence," Halverson said, "I want to address the matter of the Meridian Tower structural documentation that Ms. Rowan referenced at the close of yesterday's session." She looked at Claire. "You indicated you had documentation relating to the building's structural certification. I want that introduced and authenticated before we proceed to anything else this morning." Voss began to rise. Halverson looked at him. He sat back down. Claire stood. "Your Honor, I'm prepared to introduce that documentation. I would also request permission to call a witness in conjunction with this evidence." "Who is the witness?" "Harold Briggs, licensed structural engineer, former senior inspector with the Connecticut Department of Buildings, currently in independent practice." Halverson wrote the name down. "Mr. Voss? Any objection to the witness?" Voss conferred in a brief, low exchange with the new fourth attorney. Then, the defense requests the court's indulgence regarding the late notice of this witness. Mr. Voss, the plaintiff is self-represented and has demonstrated throughout these proceedings that her evidence is properly authenticated. I'll allow the witness. Proceed, Ms. Rowan. Harold Briggs was 61, heavy-set, with the unhurried movements of a man who had spent decades in buildings that were trying to tell him something and had learned to listen carefully. He took the stand and answered Claire's foundational questions in the flat, precise language of his profession. Credentials, methodology, the specific scope of the analysis he had conducted at Claire's request over a 4-month engagement concluded 6 weeks prior. Then Claire introduced his report. Exhibit R. She did not walk through all 94 pages. She went directly to the executive summary and read the critical sentence aloud, slowly, and then asked Briggs to explain what it meant for a general audience. He explained it the way he'd explained everything else, flatly, without drama, in the manner of a man reporting observed fact. The foundation design for Meridian Tower had been approved based on a soil analysis that indicated load-bearing capacity adequate for the proposed structure. The independent analysis Harold Briggs had commissioned as part of his review found that the original soil analysis had understated groundwater saturation levels by a factor that materially compromised that capacity. The building, as currently constructed to the 4th floor of its planned 42, was sitting on a foundation that would not support the completed structure. In Harold Briggs's professional assessment, under standard load conditions at full occupancy, the risk of partial or progressive structural failure was significant. If this building were completed and occupied, Claire said, what would that risk mean in practical terms? Briggs considered the question with the care of a man who chose words the way other people chose footing on uncertain ground. It would mean, he said, that the people living in it would be in danger. The courtroom was very quiet. How many units is Meridian Tower projected to contain? 312 residential units, estimated occupancy of approximately 600 to 800 individuals at full capacity. Claire let that number exist in the silence for a moment. Then, Mr. Briggs, in your professional career, 32 years if I have that correctly, have you encountered a situation in which a structural deficiency of this nature was submitted to the building authority for certification? Once, he said. The engineer who signed off on that certification lost his license. The contractor was prosecuted. And in this case, the structural certification for Meridian Tower was filed with the Hartford Building Authority and approved. Were you able to determine who signed that certification? The certification lists an authorized representative of Crossfield Development Partners, LLC. And were you able to identify that representative? The signature block names Claire A. Rowan. The gallery shifted. A sound, not quite a murmur, something more controlled, moved through the back rows and settled. At the defense table, the new 4th attorney leaned close to Voss and spoke rapidly. Voss's face showed nothing. Nathan's left hand was pressed flat to the table. Claire reached into her folders and removed the next document. I'd like to introduce Plaintiff's Exhibit S, she said. Credit card records, gas station receipt, restaurant receipt, and grocery receipt, all dated the Tuesday in March on which the Meridian Tower structural certification was filed, establishing that I was 300 miles from Hartford on the date my signature allegedly appears on that document, supported by phone records from a landline in Portland, Maine, attached as Exhibit T. She handed both exhibits to the bailiff. She did not look at the defense table. She looked at Halverson, who was reading Exhibit S with the focused stillness of a woman arriving at a conclusion she had been moving toward and now found herself unable to avoid. Your Honor, Claire said, I am not and have never been an authorized representative of Crossfield Development Partners, LLC. I have never been informed of or consented to any role with that entity. My signature on the structural certification is a forgery, and the notarial acknowledgement attached to it was executed fraudulently. I have provided documentation of both facts to the Connecticut Financial Crimes Task Force, with whom I understand this court has been in contact. She paused. What this means is that someone used my identity to approve a building that they knew was unsafe, so that if it ever fell, I would bear the legal and criminal liability for the deaths. The 4th attorney was on his feet. Your Honor. Sit down, Halverson said. Your Honor, The defense must strongly object to the characterization. I said, sit down. Her voice had not risen. It didn't need to. I will deal with the defense's objections in a moment. Ms. Rowan, do you have anything further on this exhibit? One item, Your Honor. Claire reached for the sealed envelope. She had carried it in the second folder this morning, beneath Exhibits R through T, and she had not looked at it during the session until now. She broke the seal, removed the document inside. 3 pages, paper clipped together, the top page bearing a notary stamp from a different notary than Margaret Ewan, authenticated 8 months ago in a process that had required 3 separate lawyers and a sworn affidavit from a forensic document examiner, and handed it to the bailiff. Plaintiff's Exhibit U, she said, an internal cross-field memorandum dated 14 months ago from Nathan Cross to Gerald Voss, discussing the Meridian Tower liability exposure and the decision to, and I'm reading directly from the document, ensure that the authorized representative structure insulates the principal from any regulatory or legal consequence arising from the foundation certification process. She turned the page. The memorandum also references, on page 2, the selection of a specific individual to serve as the named representative, chosen because she is, again, direct quotation, legally connected to the principal through marriage, has no independent legal standing to dispute the assignment, and is unlikely to discover the arrangement before the dissolution of the marriage is complete. Silence. The specific absolute silence of a room in which everyone present has understood something simultaneously. Claire set the document down on the plaintiff's table and looked at Nathan Cross for the first time in 3 hours. He was looking back at her. His face had finally, completely, stopped performing. What was beneath the performance was not what she had expected. She had expected the calculation, the reassessment, the rapid internal restructuring she had watched him do in boardrooms and courtrooms and across dinner tables for 15 years. She had expected the machine to keep running. It wasn't running. What was on Nathan Cross's face, stripped of everything he had spent 53 years building over it, was something rawer and smaller and more recognizable than anything he had ever let her see. She looked at it for exactly as long as she needed to understand what it was. Then she looked back at Halverson. No further questions for this witness. What? The recess that followed lasted 22 minutes, during which Claire sat alone at the plaintiff's table and did not move. The gallery emptied into the corridor. She heard Halverson's clerk making calls from the judge's chambers, low, quick, professional calls that had a different urgency in them than the administrative routine of the previous 2 days. She heard Voss's voice in the corridor, its modulation finally cracking open at the edges. She heard Nathan's voice once, saying something clipped and sharp, and then not hearing it again. She heard Lena Brooks' heels on the marble outside the door, pausing, and then continuing. She sat and breathed and kept her hand still on the table. When Halverson came back to the bench, she brought with her an expression that Claire had seen on the faces of certain people at certain moments. The expression of someone who has made a decision they will not revisit. Not satisfaction, not anger. Something past both of those. The expression of a judge who had looked at what was in front of her and understood that her function in this room had changed. "Mr. Voss," Halverson said, "I'm going to give you an opportunity to speak before I act because that is what this court's procedures require. But I want you to understand that my patience in this proceeding is no longer what it was this morning." Voss stood. He was controlled still. She would give him that. She had always given him professional credit, even as she'd worked to dismantle everything he'd built in this room. But he was controlled the way a structure is controlled under load, and the load had increased. "Your Honor," he said, "the defense requests a full adjournment to allow time to review the documentation that has been introduced." Denied. "Your Honor, the authenticity of Exhibit U has not been—" "The authentication documentation for Exhibit U," Halverson said, "includes a sworn affidavit from a forensic document examiner with 28 years of credentials and a certification from a notary who has not been implicated in any of the fraudulent notarial activity this proceeding has documented. The exhibit is admitted." She set her pen down. "Mr. Voss, I'm going to ask you a question, and I expect you to answer it carefully. The memorandum in Exhibit U appears on Crossfield Company letterhead and bears what purports to be your client's electronic signature. Do you have any information that would cast doubt on its authenticity?" A silence. Long enough to be its own answer. The defense reserves the right to, do you have information casting doubt on its authenticity? Yes or no? Voss said nothing. Halverson looked at Nathan. Mr. Cross, do you wish to address the court regarding Exhibit U? Nathan sat forward slightly. His lawyers, all four of them, shifted in collective automatic response, a wall of expensive suits instinctively closing around him. He looked at them, one by one, briefly, and then he looked at the judge. And then he looked at Claire. It lasted 2 seconds, maybe 3. And in those seconds, she watched him do the things she had watched him do across 15 years of marriage in every situation where the variables shifted beyond what his strategy had accounted for. She watched him locate the exit, the way out, the move that preserved the most from whatever was being lost. She watched him find it. She saw it happen in his eyes, the flicker, fast, the specific intelligence of a man who had always, in every room he had ever been in, found the exit before anyone else. And then she watched him look back at the judge and say nothing. Because this time there was no exit. She had built the case around every door. At 4:17 that afternoon, while Halverson was reviewing a procedural motion from Voss's fourth attorney that she had already indicated she intended to deny, Claire's phone buzzed under the table. Diane Chu. She stepped into the corridor to take it. "We found Margaret Ewan," Diane said without preliminary. "She's talking." "What is she saying?" "Enough." A pause. "Claire, there's something else. When we brought her in, she had documentation we weren't expecting. A second liability transfer, not the one Marcus found. This one is dated 6 days ago." Claire's hand tightened on the phone. "What entity does it transfer to?" "Same structure. Your name as authorized representative. But this one doesn't attach to Meridian Tower." Diane's voice was careful, each word placed precisely. "It attaches to a fund that holds 3 other cross-field development projects. Total valuation approximately $240 million. Total liability exposure if any of them encounter regulatory or structural issues? How much?" Diane said the number. Claire stood in the corridor of the Hartford County Courthouse and heard the number and felt the ground shift under her in a way that had nothing to do with foundations or soil analysis. She felt it the way you feel a temperature drop, suddenly, completely, in the whole surface of your skin at once. She had built her case around the assumption that Nathan's fraud was what it appeared to be. A financial concealment scheme with a liability backstop built from her identity. She had not considered that the backstop was still growing. That while she had been in this courtroom for 3 days dismantling his past, he had been outside it, through his attorneys, through Margaret Ewan, through whatever instruments he still had moving, constructing a new exposure around her name that dwarfed the original. She had not stopped him. She had accelerated him. "Claire," Diane said, "are you there?" "I'm here." "We're moving tonight. I have authorization for warrants, but there's a procedural issue with the liability transfer. The way it's structured, if it gets recorded before we can freeze it, your name becomes attached to those assets in a way that's going to take months to unravel, even with everything you have." Another pause. "I need to know if you have something that directly connects Nathan Cross to Margaret Ewan's involvement. Not the building certification. Something from before, something that shows he directed the notary fraud specifically." Claire thought about the sealed envelope, the document she had introduced as Exhibit U that morning. She thought about the second drawer of her kitchen table. She had brought the memorandum. She had not brought everything. "I have a phone record," she said. "Nathan's personal cell to Margaret Ewan's office. 14 calls over 6 months. The first one predates the Meridian Tower certification by 3 weeks. Can you get it to me in the next 2 hours?" Claire looked through the small window in the courtroom door. Halverson was still on the bench. Voss's fourth attorney was still presenting his motion. Nathan was sitting with his hands folded and his face back under control, the mask rebuilt with whatever was left of his materials, performing composure for a room that had already stopped believing the performance. She thought about the text message. "You should stop now." She thought about Sarah Novak and 12 days and the shape of a trap built from the materials of her own preparation. She thought about Lena Brooks standing in a corridor in a coat too thin for November, with a phone in her hand and an email she'd had the presence of mind to forward before she walked through the door. And what it meant that the person Nathan had tried to use as a liability vessel had instead become the instrument of his exposure. She thought about her father and the kitchen table and a Tuesday in November and the first thread she had ever pulled. "Yes," she said into the phone, "I can get it to you." She ended the call, stood in the corridor for one more moment. The marble floor under her feet was solid and cold and very still. The overhead lights buzzed their quiet, bureaucratic buzz. Down the hall, a door opened and closed, and a court reporter walked past with her equipment case and did not look up. Claire put her phone in her pocket, straightened her blazer, put her hand on the courtroom door. She pushed it open and walked back in, and the weight of what was coming, what she had built, and what had been built against her, and what she was going to have to become to survive the distance between those two things, settled onto her shoulders like something she had been carrying for a long time and had only just now decided to stop pretending wasn't there. She had 90 minutes. That was what Diane Chu had given her, 90 minutes between the end of the court session and the window in which the liability transfer could be recorded with the Connecticut Secretary of State's office, which closed at 6, and which Diane's team could not legally prevent from processing a document that had been properly submitted before any freeze order was in place. The warrants were being drafted. The freeze order was being drafted. Everything was being drafted. And drafting took time. And time was the one resource Nathan Cross had apparently decided to weaponize. Claire came out of the courthouse at 4:43, moving faster than she had moved in 3 days, her folders under one arm and her phone already dialing Marcus. "I need the phone records. Nathan's cell to Margaret Ewan, the call log I pulled in August. I have it digitally, but the certified copy is at my office. I'll come to you. Don't leave." She ended the call and pulled her car keys from her coat pocket and was already halfway down the courthouse steps when she heard someone say her name. Not loudly, not the way a stranger says it. The way someone says it who has been waiting in a specific place for a specific amount of time and has decided this is the moment. She stopped, turned. Nathan was standing at the bottom of the steps, alone. No Voss, no junior attorneys, no fourth counsel. Alone in his charcoal suit in the cold November air, with his hands loose at his sides and his breath making small white shapes in the 4:40-something dark that came early in November in Connecticut and didn't apologize for it. She stood 6 steps above him. The height difference made something she felt in her chest that she didn't have a clean name for. "The session is over," she said. "I know that." "Then you know you can't be talking to me outside of... Voss doesn't know I'm here." He said it quietly. Not as a confession, as a fact he was laying down between them, clearing space. "No one does." Her hand tightened on the folders. She made herself keep still. "What do you want, Nathan?" He looked at her. His face was doing something she had last seen it do at a dinner in New York, 8 years ago, when a deal he'd spent 14 months building had collapsed in the space of one phone call, and she had watched him sit across from her at a restaurant table and recalibrate everything in real time. Silent, the way a gyroscope recalibrates. Not dramatically, just inexorably, finding level. She had found that quality extraordinary at the time. She had found it frightening later. She was finding it something else now, watching it aimed at her from the bottom of courthouse steps. "Stop the phone records," he said. "Don't give Chu what she's asking for tonight." "No." "Claire, no." She came down 2 steps, stopped, kept the distance. "You built a trap with my name on it. You built it while I was standing in that courtroom doing what you always told me I wasn't capable of. And now you're standing here asking me to let you out of it." She shook her head once, very small. "No. If you give Chu those records tonight, what happens next isn't just me." His voice had changed, stripped of the modulation, the professional surface. This was the voice she'd heard at 2 a.m. when he thought she was asleep, when he was on the phone with Voss or with someone from the Luxembourg end of things, raw and fast, and entirely without performance. "There are people involved in this who are not going to accept a federal investigation quietly. People who are not..." He stopped. His jaw worked once. "People who have more resources than a fraud warrant." She felt the cold of the steps through the soles of her shoes. She felt her own heartbeat, which had gone to something measured and deliberate. the way it went when she needed to be accurate. Is that a threat? It's a fact. It sounds like a threat. It sounds like the truth, and you know the difference. He took one step up. She held her position. I'm telling you, there are components of this that I cannot control from where I'm standing in the next 24 hours. I'm telling you that if you push past a certain point tonight, what comes back at you will not look like a phone call or a text message. Her breath was cold in her chest. She thought about 4 words on a phone screen. You should stop now. She thought about Sarah Novak and 12 days and the shape of a case built around a woman who didn't know she was being observed. She thought about Lena Brooks in a corridor in a coat too thin for November. You should have thought about that, she said, before you put my name on a building that was going to fall on 800 people. She came down the rest of the steps and walked past him and did not look back. She heard him, behind her, say something. One word. Her name. Just her name. The way he had said it in the corridor after the first session. Not a call, not an instruction, not any of the things his voice had been for 15 years. Just the word itself, stripped of everything around it, existing for one moment in the cold air between them. She kept walking. Marcus Delaney's office was 12 minutes from the courthouse, and she made it in 9, running 2 yellow lights and parking badly in the loading zone outside his building. He met her in the lobby with the certified phone records already in a sealed envelope. He had anticipated, she realized, the way he always anticipated, the careful, methodical foresight that had made 14 months of work possible, and she took them from him and held them for a moment with both hands. There's something else, he said. She looked up. His face was doing the thing it did when he had information that was going to change the shape of something she already understood. She had learned to recognize that face. It was not alarmed. It was precise in the way of someone who has looked at a set of numbers and arrived at a conclusion the numbers didn't intend to give him. Margaret Ewan, he said. When Diane's team brought her in, she gave them the notary log, the official record of every document she's certified in the past 5 years. I know that. The log has 43 entries tied to crossfield entities. He paused. Entry 44 is not a crossfield entity. Claire waited. It's a personal document, a transfer of ownership, executed 8 months ago. He took a breath. Claire, Harold Briggs, your structural engineer, his independent practice, the LLC he operates through. It was acquired 8 months ago by a holding company with nominee directors registered in Delaware. The cold she'd been carrying since the courthouse steps spread outward and settled into something specific and very still. What holding company? It traces back 3 steps, takes about 40 minutes to run the chain. His voice was even. It's Nathan's. The lobby of the building was quiet around them. The distant sound of the elevator, the flicker of fluorescent light, the faint noise of the street outside. She stood in it and breathed and let the information rearrange itself around the new shape it had just taken. Harold Briggs. 12 years at the Connecticut Department of Buildings. 32 years of credentials. The man she had hired because he had been recommended by a contact she trusted, because his report had been thorough and independent and devastating in its conclusions, because she had read his 94 pages and found nothing in them that felt like anything except the careful, professional observation of a man who had learned over 32 years to tell the truth about what he saw on the ground. But if Nathan owned the LLC, the report, she said. Is the report real? I don't know. Marcus's voice was honest, and that was the only thing she could hold on to in that moment. That Marcus Delaney had spent 14 months being honest with her in the specific, unflattering way of a forensic accountant who did not believe in softening numbers. The structural findings are consistent with everything the soil analysis showed. But if Briggs is compromised, if he was placed specifically to give you a report that you'd introduce in court, then Nathan controls what's in the report. She thought. Fast, hard, the way she'd been thinking for 3 days without sleep and counting. He controls what Briggs says on the stand. He can have Briggs recant. He can have him testify that he was pressured, that the report was overstated, that the structural concerns were exaggerated by a plaintiff trying to manufacture a criminal case against her ex-husband. She heard her own voice doing it, laying it out, building the shape of the trap, the way Nathan's version of this would look, in the hands of a skilled attorney in front of a judge who had just spent 3 days watching Claire Rowan's case appear impenetrable. It blows up the structural evidence, it blows up the criminal referral, and it makes everything I introduced this week look like fabrication. Claire, how long have you known this? I found it 40 minutes ago. He held her gaze. I called you immediately. She believed him. She believed him because she knew his face and because she had trusted it for 14 months, and because some things you cannot afford not to believe. She pressed the back of her hand against her mouth for exactly 3 seconds. Not composure, something past composure. The physical act of holding something in long enough to convert it into something usable. And then she took her hand away. I need Diane, she said. Now. Diane Chu answered on the first ring, which meant she was already holding the phone. I know about Briggs, Claire said. A pause, short. When did you find out? 6 minutes ago. Did you know before tonight? We flagged the LLC connection an hour ago. I was going to tell you when you came in. Another pause, and in the pause, Claire heard the specific quality of a person deciding how much truth the situation required. Claire, I need you to understand where this puts the structural evidence. I understand exactly where it puts it. If Briggs recants, he won't. She said it before she fully knew why, and then she followed her own certainty backward to find the reason, the way you follow a thread back to where it's anchored. Harold Briggs. The lobby of his office in September, 4 months ago, the smell of old coffee and engineering drawings. The way he'd spread the soil analysis across the conference table and traced the numbers with one finger and said, in the flat voice of a man describing something that troubled him, "This isn't a mistake. Mistakes look different from this. This is a decision." She had watched his face when he said it, and she had seen something in it that she recognized from her father's face. The expression of a person who had spent a career believing in the integrity of their profession and was looking at evidence that someone had used that profession as an instrument of harm. He did not write that report for Nathan. He couldn't have. You read what he said on the stand today, the way he said it. Claire, I have to go on evidence, not instinct. Then go on this. She was walking, the phone to her ear, moving back toward her car through the dark and the cold. Nathan's LLC acquired Briggs's practice 8 months ago. Briggs has been in independent practice for 11 years. If Nathan bought him to place a compromised expert, why did it take 8 months? Why not place him from the beginning, before I'd built enough of the case to need a structural engineer? Why wait until I'd already found the Meridian Tower permit records and started asking questions about the foundation? She reached her car, stopped. Because Nathan didn't buy him to compromise him. He bought him to control him. Those are different things. And Harold Briggs hasn't been controlled yet because Harold Briggs doesn't know his LLC was acquired. I'd bet everything on that. The line was quiet for 4 seconds. If he doesn't know, Diane said slowly, then he's not compromised. He's a hostage. Yes. And Nathan's plan is to tell him tonight. Before tomorrow's session. Yes. She got into the car. Diane, I need you to get to Briggs before Nathan does. I need him told about the LLC acquisition, from us, not from Nathan, and I need him given the opportunity to cooperate voluntarily before he's approached with whatever leverage Nathan is planning to use. That is, Diane stopped. Claire heard the sound of movement on the line, the specific sound of someone standing up, of energy converting into action. That is something I can do. I need 30 minutes. You have 20. She ended the call. Sat in the parked car in the dark loading zone outside Marcus's building with both hands on the steering wheel and the sealed envelope with the phone records on the passenger seat and the engine not yet running. Her phone showed 4:59. The Secretary of State's office closed at 6, 58 minutes. She called Diane back. The phone records, I have them. Where do you need them? My office. But Claire, I also need something from you that I should have asked for yesterday. What? A sworn affidavit, attesting to the chronology of your discovery of the Meridian Tower documentation and the sequence in which you obtained each piece of evidence. Chain of custody, essentially. If we're going to move on Nathan tonight and have it stick, I need your testimony on record before his attorneys can argue that you fabricated the evidentiary trail. She thought about how long that would take. She thought about 57 minutes. "I'll dictate it on the way," she said. "Have your paralegal ready to transcribe." She started the car. "Mom." The drive to Diane's office took 11 minutes, and she spent 10 of them on the phone dictating, not slowly, not with the care she would have taken if she had the time for care, but with the specific rapid accuracy of someone reciting from memory a sequence of events they had lived, every date precise, every action described in the active voice her law school professors had drilled into her students, and which she had never entirely forgotten, even in the 15 years she'd spent not being a lawyer. She was signing the printed affidavit in Diane's conference room at 5:23 when her phone rang. Unknown number. She looked at it. Diane looked at her. She answered. The voice was not Nathan's. It was a woman's voice, low, controlled, with the compressed quality of someone speaking from a small space or speaking quietly by intention. It said, "Ms. Rowan, my name is Angela Voss." Claire set the pen down. Gerald Voss had a daughter. She knew this the way she knew the shapes of many peripheral things in Nathan's professional world, from documents, from a brief review of Voss's firm biography, from the background she had run on every significant figure in the defense structure. Angela Voss was 34, had worked briefly at her father's firm before moving to a nonprofit, and had not appeared anywhere in Claire's case preparation as a relevant figure. "Ms. Voss," Claire said. Her voice was even. "Why are you calling me?" "Because my father made a decision tonight that I couldn't stop and I couldn't stay silent about." A breath on the line, unsteady at the edges. "He filed a motion 2 hours ago, emergency motion, to have you declared a vexatious litigant under Connecticut statute, which if granted would allow the court to require you to post a substantial bond before continuing the proceedings, a bond that would be set at the court's discretion." Another breath. "He filed supporting documentation arguing that the Meridian Tower evidence was fabricated, that Harold Briggs was coerced, that the memorandum in Exhibit U, the one connecting Nathan to the liability transfer, was produced through document fraud." Claire was on her feet. She didn't remember standing up. "On what basis?" "He has an affidavit from Sarah Novak." The name landed like a flat hand on a table. Diane was watching Claire's face and must have seen something in it, because she was already reaching for her own phone. "Sarah Novak," Claire said carefully, "is a paralegal who worked for me for 12 days and then went to work for your father's firm." "I know that." "Her affidavit is perjury." "I know that too." Angela Voss's voice had something in it that was not quite grief and not quite anger. The specific sound of a person watching something they cannot stop and choosing at the last possible moment not to look away. "She says you coached her, that you told her to organize documents in a specific sequence to make the fraud evidence appear more substantial than it was, that you fabricated the timeline of the Briggs engagement, that Exhibit U, the memorandum, she helped you create it." Claire stood in Diane Chu's conference room and felt the ground move in a way that was entirely different from the way it had moved in the courthouse corridor with Marcus. This was not the cold spread of new information reconfiguring a known structure. This was the specific sensation of a floor you have been standing on for a long time, revealing that it was never as solid as you believed. They were going to try to destroy her in the courtroom, not with Nathan's money, not with Voss's procedural skill, not even with the liability transfer or the forged signature. They were going to try to destroy her with a 24-year-old paralegal who had sat in her workspace for 12 days and now had a sworn affidavit and whatever Gerald Voss had decided to offer her for it. "Why are you telling me this?" Claire said. Angela Voss was quiet for a moment. "Because I've been watching my father represent men like Nathan Cross for 20 years, she said. "And I'm tired." Claire looked at Diane. Diane was already writing something on a notepad and pushing it across the conference table. The notepad read, "Can she testify?" Claire held the phone between her shoulder and her ear and wrote on the same notepad, "She's calling voluntarily." "Yes." "Ms. Voss," she said, "I need to ask you something and I need you to answer honestly. All right? Does your father know you've seen the motion?" "He left it on his desk. I was in his office returning a file. He doesn't know." "Do you have access to the supporting documentation, the Sarah Novak affidavit?" A pause. "I photographed it." Claire's chest did something that was not quite a breath and not quite relief, something between them, the physical sensation of a door opening in a wall you had stopped believing contained a door. Send it to the email on my court filing, right now, before he comes back to his office. She wrote the address on the notepad and read it aloud. And then I need you to be somewhere your father can't reach you for the next 4 hours. Can you do that? Yes, Ms. Voss. She stopped, started again. Angela, what you're doing right now, I need you to understand what it means. It means you'll have to say this in court, in front of your father. The silence on the line lasted long enough that Claire thought she might have lost her. Then Angela Voss said very quietly, I know. The call ended. The photograph of Sarah Novak's affidavit arrived in Claire's email 40 seconds later. She and Diane read it standing over the conference table, shoulder to shoulder, and the quality of the silence between them as they read was the silence of two people who are moving very fast inside and very still outside because there is no other way to do what needs to be done next. The affidavit was 12 paragraphs. It was carefully written. Voss's language, Claire could hear it, the specific rhythm of his sentences built into Sarah Novak's voice the way a blueprint gets built into a building. It was detailed and internally consistent and almost entirely false, and it would require, in front of Judge Halverson tomorrow morning, a response that was equally detailed and supported by evidence that Claire did not currently have assembled in a form the court could receive in the time available. Almost entirely false. She read it again, slowly this time, and on the second read she found the thing she had missed on the first, the detail that Voss had included because it made the affidavit more specific, more credible, more granular in its account of Claire's supposed document manipulation, without realizing that the detail itself was the thread. Sarah Novak's affidavit claimed that on a specific Tuesday in August, Claire had instructed her to relabel a series of forensic accounting reports with altered dates to make the chain of discovery appear sequential rather than simultaneous. The affidavit specified the date. It specified the afternoon. It specified the room, Claire's spare bedroom, which she used as a workspace. On that specific Tuesday afternoon in August, Claire had been at Marcus Delaney's office in New Haven. She had signed a document there. The document was in Marcus's files. She straightened up. Her back ached. Her eyes were dry and sore. She had been awake for 36 hours, and her hands, when she looked at them, were not shaking. Marcus, she said, call him. I need the sign-in log and the document from his New Haven office, August 12th, afternoon session. I need it tonight. Diane was already on her other phone with someone from the Financial Crimes Division. She held up one finger, give me a second, and then said into her phone, I need Briggs tonight. I need him before 9 tomorrow morning. I don't care what it takes. Get him. The clock on the wall of Diane's conference room read 5:41, 19 minutes to the Secretary of State's office closing. Diane's other line rang. She answered, listened for 10 seconds, and held the phone away from her ear and looked at Claire with an expression that was not triumph. Diane Chu did not deal in triumph, but was the closest thing to it that her face produced. The freeze order came through, she said, 4 minutes ago. The liability transfer cannot be recorded tonight. Claire sat down. She sat down because her legs wanted her to, and she had been fighting them for 3 days, and she allowed it, just this once, for 30 seconds. She sat in the chair at Diane Chu's conference table and felt the weight of the past 72 hours in her back and her neck and the small, persistent ache behind her eyes, and she looked at the ceiling and breathed. Then she picked up the phone records from the passenger seat. She had carried them in without realizing, the muscle memory of someone who had learned not to let important documents out of arm's reach, and set them on the table. What do we do about Voss's emergency motion? She said. Diane sat across from her. She had the notes from the last hour spread out between them, affidavit, phone records, Marcus's timeline, Angela Voss's photograph, the freeze order confirmation still showing on her phone screen. She looked at all of it with the flat, analytical gaze of a woman who had spent her career reading the numbers inside complicated disasters and identifying the one that changed everything. We go to Halverson tonight, Diane said. Right now. Emergency ex parte application. We present the Novak affidavit. We present Angela Voss's account. We present the chain of evidence establishing the affidavit is perjured, and we ask the judge to deny the emergency motion before Voss can bring it in the morning. She paused. If Halverson grants us that tonight, We walk into that courtroom tomorrow and Nathan Cross has nothing left. Claire looked at her. And if she doesn't grant it? Then tomorrow morning, Gerald Voss walks into that courtroom with a motion that could stop these proceedings, and we fight it in open court with everything we have, and we win anyway. Diane held her gaze. But I'd rather not do it that way. Claire thought about the way Nathan had looked at the bottom of the courthouse steps, the raw, stripped thing she had seen in his face when the performance finally gave out. She thought about the building, 4 floors of it sitting on inadequate ground in downtown Hartford, half a mile from where she was sitting, and the people who would eventually live in it if no one stopped it. She thought about Harold Briggs saying, "This isn't a mistake. Mistakes look different from this." She thought about Lena Brooks in a coat too thin for November with a phone in her hand. She thought about a Tuesday in November 2 years ago and a $40,000 transfer on a laptop screen. "Call Halverson's clerk," she said. She was already gathering the documents. Judge Patricia Halverson received them in her chambers at 6:51 in the evening, still in her judicial robes because she had not left the building, which told Claire something about what kind of woman sat on the bench of courtroom 4B when she wasn't performing the ritual of the bench. Her chambers were sparse and somewhat cluttered in the way of a person who read a great deal and had stopped pretending to organize it. Stacks of briefs, a coffee mug that had been washed and dried and used many times, a single photograph on the desk that Claire did not look at because it was not hers to look at. Halverson read the Sarah Novak affidavit in 4 minutes without speaking. Then she read Angela Voss's account, transcribed from the call recording Diane had made with Claire's knowledge and consent. Then she looked up. "Where is Angela Voss now?" "Safe," Claire said. "Available to testify tomorrow." "And Harold Briggs?" Diane said. "In our offices as of 30 minutes ago, cooperative. He had no knowledge that his LLC had been acquired. When he was informed, his response was to request immunity and provide us with a secondary copy of his structural analysis from a personal backup drive." She set a folder on Halverson's desk. "The analysis is consistent with what he submitted as Exhibit R. The report is authentic." Halverson looked at the folder, did not open it yet. She looked between Claire and Diane for a moment with the expression of a woman whose professional patience had been rewarded in a way she had not quite anticipated. "Ms. Rowan," she said, "I've been on this bench for 19 years. I've seen a lot of people represent themselves in this court." A pause. "I don't think I've seen anyone do what you've done in the last 3 days." Claire said nothing. Her back hurt. Her eyes hurt. She had eaten a granola bar in Diane's conference room at some point in the last 2 hours. And that was all she'd eaten since breakfast, and she was aware of it the way you become aware of things when the body stops being willing to be ignored. "I'm going to deny Voss's emergency motion," Halverson said. She said it the way she said everything, flatly, with the authority of someone who had made a decision and was reporting it rather than announcing it. "I'm also going to issue a notice tonight that I expect both parties present tomorrow at 9 and that the court intends to address matters beyond the scope of the original divorce petition." She looked at Diane. "Ms. Chu, how many federal warrants are you prepared to execute?" Diane said, "As many as the evidence supports, Your Honor." Halverson nodded once. "Then I'll see you at 9. She was already reaching for her phone as they stood to leave. Claire was halfway to the door when she heard the judge's voice behind her, not directed at anyone in particular, said in the same flat tone as everything else. "Miss Rowan, go home and sleep." She did not go home and sleep. She drove to the apartment and showered and changed into clean clothes and sat at the kitchen table with the folders arranged in their final order for the morning, everything authenticated, everything sequenced, the last of the exhibits numbered through to the end. She made coffee and drank half of it. She called Marcus and thanked him in the specific, brief way he appreciated, without excess. She checked her phone and found a message from Lena Brooks that said, only, "I'll be there tomorrow," and replied with a single word. She sat in the kitchen for a while after that. The folders were done. The preparation was as complete as preparation could be, and anything she added to it now would be anxiety dressed as productivity, and she recognized the difference. She thought about Nathan at the bottom of the courthouse steps. People who have more resources than a fraud warrant. She did not know yet whether that had been a real threat or the last performance of a man running out of instruments. She would know tomorrow. She would know by the quality of the air in the room when she walked in, and by the particular way Gerald Voss arranged his face, and by whether there were new people in the gallery who had not been there before. She had done everything she could do tonight. She had done, in fact, more than she had believed 3 days ago she would be able to do. More than the case required, more than the divorce required, more than the 18 months of kitchen table work had prepared her to expect. She had done it without an attorney, without the institutional support of a firm or an office or the credentialing that marked you as someone the court was accustomed to taking seriously. She had done it as the woman Nathan Cross had spent 15 years explaining to people, and to herself, was not capable of doing it. She turned off the kitchen light, went to bed, lay in the dark. Her phone buzzed once. She looked at it. It was from a number she didn't recognize. Not the unknown number, a different one. The message was 3 lines long. FYI. Voss resigned from the case 20 minutes ago. Nathan's remaining counsel is requesting a continuance until he can secure new representation. They're going to try to delay. Don't let them. She stared at the message for a moment, then she typed back, "Who is this?" The response came in 4 seconds. "Someone who was in that room today and is very glad you were there." She put the phone down, lay back, closed her eyes. Tomorrow, Nathan Cross was going to walk into Courtroom 4B without his lead attorney, without his emergency motion, without the Briggs recantation, without the liability transfer, without the Sarah Novak affidavit, without the forged signature on the building certification, without the nominee directors, without the offshore accounts, without the 15 years of architecture he had built to make himself invulnerable and to make her invisible. Tomorrow he was going to walk in with nothing but what he had always actually had, the money, the suits, the pale gray eyes that performed certainty, and she was going to be standing at the plaintiff's table with everything else. She slept for 4 hours. When she woke at 5:15, the light was the same gray it always was, and the folders were on the kitchen table exactly where she'd left them, and the phone on the nightstand had no new messages from unknown numbers. She got up, made coffee, stood at the window. The city was still dark and starting to move, the early shapes of it emerging through the glass, headlights, a delivery truck, the slow, patient arrival of morning over buildings that were, most of them, solidly built on ground that would hold them. She picked up her coat, picked up her folders, walked to the door. She arrived at the courthouse at 8:41. The parking garage was fuller than it had been on any of the previous 3 mornings, and she understood why before she reached the elevator. There were 2 news vans parked on the street outside and a cluster of reporters near the main entrance who turned toward her as she came around the corner with the specific movement of people who have been waiting and have identified their subject. She kept walking. Someone called her name. She did not stop. The lobby was different too. More people moving with more purpose, the low-grade hum of institutional machinery shifting into a higher register. She recognized 2 faces from the Financial Crimes Division, Diane's people, in the specific plainclothes that was not quite casual, positioned near the corridor that led to Courtroom 4B. One of them gave her a nod so small it was almost nothing. She nodded back. She went to the women's restroom at the end of the corridor, stood over the sink, ran cold water over her wrists for 60 seconds, and looked at her face in the mirror. The same face it had been for 4 days now, dark-eyed and tired and set in the particular way of someone who has been moving towards something for a long time and has arrived and is taking stock of what arrival actually feels like. It felt like work. That was the honest answer. It felt like there was still work to do. She dried her hands and went to the courtroom. Well, Nathan was already there. He had 1 attorney with him, not Voss, not the 4th outside counsel from the day before. A woman Claire didn't recognize, 50-ish, with close-cropped hair and the composed, evaluating expression of someone brought in at short notice who had spent the night reviewing documents and had decided she understood the situation well enough to proceed. She was already in conversation with the bailiff when Claire entered, and she glanced over once, assessing, quick, professional, and then looked back at the bailiff. Nathan sat at the defense table and did not look up when Claire came in. She watched him for a moment from the door, the way she had watched him at that charity auction 23 years ago, before she had understood what she was actually seeing. He was sitting the way he sat, upright, contained, the suit precise. But the quality of it was different. The performance of composure had always required an audience and a belief, however small, that the performance was working, This morning he was performing for no one, and she could see the effort it took now that the belief was gone. The slight overstatement of the stillness, the jaw held just a fraction too even, the hands flat on the table with the deliberate care of someone who no longer trusted them to be still on their own. She sat down at the plaintiff's table, set her folders in their order, uncapped her pen. At 9:02, Judge Halverson entered and the room came to order. She did not sit immediately. She stood at the bench and looked at both tables and at the gallery. Fuller than it had been, the back rows standing, with the expression of a judge who had made her preparations and was not going to waste the morning explaining them. "Before we proceed," Halverson said, "I want to address the defense's request for a continuance filed last night. That request is denied." She looked at Nathan's new attorney, whose name Claire still didn't know. "Counselor, your client has had representation throughout these proceedings. A change in that representation does not alter the court's schedule. We are proceeding today." The attorney began to rise. "Your Honor, the defense would argue that adequate preparation requires— The defense has had 3 days to observe the plaintiff's evidence and methodology," Halverson said. "I don't imagine the past 12 hours have changed the shape of it significantly. We proceed." She sat. "Ms. Rowan, you indicated yesterday that you had additional exhibits and at least one remaining witness. We'll begin there." Claire stood. She had thought carefully, in the 4 hours she'd slept and the hours she'd been awake before coming here, about how to begin this morning. She had thought about sequence and timing and the specific weight of information presented in a particular order, the way her father had thought about forensic accounting narratives. Each number placed where it would be understood, not just seen. She had thought about the Sarah Novak affidavit and Angela Voss and Harold Briggs, and the anonymous text message and the photograph of a freeze order on Diane Chu's phone screen. She had thought about Nathan at the bottom of the courthouse steps, saying her name like a word he'd forgotten how to use. She began with Angela Voss. Tot. Angela Voss took the witness stand at 9:17, and the room understood immediately that something had shifted. She was composed in the way of someone who has already paid the cost of a decision and is no longer afraid of it, the specific steadiness that comes not from certainty, but from having moved past the point where certainty would have changed anything. She was wearing a dark blazer and had her hands folded in her lap, and when she looked at the defense table, she looked at it directly, without flinching and without apology. Claire walked her through the facts in the precise, methodical sequence that produced a clear picture without ornamentation. Angela had been in her father's office returning a file. She had seen the emergency motion on his desk. She had read it. She had read the Sarah Novak affidavit attached to it. She had photographed both documents and called Claire Rowan. Nathan's attorney rose. "Your Honor, this witness has no direct knowledge of the facts at issue in this proceeding. She has direct knowledge of a document filed with this court," Halverson said. "I'll allow it. Continue." "Ms. Voss," Claire said, "when you read the Sarah Novak affidavit, what was your assessment of it?" A pause. Not hesitation, consideration. The difference between a person who doesn't know what to say and a person who is choosing the exact right words from among several accurate options. "It was false," Angela Voss said. "I've worked in legal practice for 6 years. I know what a fabricated affidavit looks like, and I know what it looks like when someone else's voice has been built into another person's statement." She stopped, breathed. "My father is a skilled attorney. What he wrote in Sarah Novak's voice was technically careful, but it described events that I was able to determine, from reviewing the plaintiff's filed exhibits and their documented timestamps, could not have occurred in the manner described." "Can you identify specifically which claim in the affidavit is verifiably false?" Angela looked at the document in front of her. Claire had given her a copy before the session. Paragraph 7. The affidavit claims that on August 12th in the afternoon, Ms. Rowan directed Sarah Novak to relabel forensic accounting documents in the plaintiff's home workspace. She looked up. August 12th is the date Ms. Rowan signed an engagement letter at Marcus Delaney's offices in New Haven. The timestamp on that letter is 2:47 in the afternoon. The offices are 64 miles from Ms. Rowan's apartment. She set the document down. She was not in her apartment that afternoon. Halverson was writing. Nathan's attorney rose. "Your Honor, the witness cannot authenticate. The engagement letter has been provided to this court as supporting documentation," Claire said. Authenticated, notarized, and supported by a sign-in log from Mr. Delaney's office building. Plaintiff's Exhibit 5. She handed it to the bailiff. I also have Mr. Delaney available to testify to the same facts if the court requires it. Halverson looked at the exhibit. Then she looked at the defense table with an expression that had moved past patience, past impatience, past the judicial formality that had structured the first 3 days, into something flat and final. Counselor, she said to Nathan's attorney, I'm going to give you the same question I gave Mr. Voss yesterday. Do you have any information casting doubt on the authenticity of this documentation? The attorney looked at Nathan. Nathan was looking at the table. No, the attorney said. Sarah Novak appeared as a witness for the plaintiff at 10:45, which was a development that Nathan's attorney had not anticipated and which produced, when Claire called the name, a sound from the defense table. Not words, just a brief exhale, the sound of an air pocket in the machinery. Sarah Novak was 24 and pale and had the specific look of a person who had been awake longer than they should have been and was carrying something that had gotten heavier in the night. She took the stand with the careful movements of someone very aware of being observed, and when she was sworn in, she looked at Claire with an expression that was not quite guilt and not quite relief. Something between them, something raw. Diane Chu had spoken with Sarah Novak the previous evening. Claire did not know exactly what had been said, she had not been in the room, but she knew the shape of it because she knew how these conversations went, and because the expression on Sarah Novak's face was the expression of someone who had been shown clearly what they were standing at the edge of and had made a choice to step back. Ms. Novak, Claire said, you worked for me for 12 days in August. Yes? And you subsequently took a position at Voss, Klein, and Hartley. Yes. While employed there, were you asked to provide a sworn affidavit regarding your time working for me? A breath. Very short. Yes. Was the affidavit you signed an accurate account of what occurred during your 12 days working for me? Sarah Novak looked at the table in front of her for exactly 3 seconds. Then she looked up. Her eyes were dry, and her voice, when she spoke, was steady in the way of something that has decided to be steady and is committed to it. No, she said. It wasn't. The gallery shifted. Nathan's attorney was on her feet, but Halverson's hand came up before she finished rising, and she sat back down. Miss Novak, Claire said, can you describe what actually occurred during your employment with me? I organized documents. I helped create an exhibit list. I did paralegal work. She stopped. I didn't see Ms. Rowan fabricate anything. I didn't hear her instruct anyone to alter document dates. The things in the affidavit, she pressed her lips together once, briefly. Someone else wrote those things. I signed them because I was told it was a standard protective declaration, and because I was 24 years old and I made a bad decision. Who told you to sign the affidavit? Gerald Voss. Did he explain what it would be used for? He said it was precautionary, that it might be needed to protect the firm's client. She exhaled. He didn't tell me it was going to be filed in court. He didn't tell me what it actually said. Her voice had something in it now, not anger, something more tired than anger, the sound of a person who has fully understood something they'd been not quite understanding for months. When Diane Chu showed it to me last night, it was the first time I'd read all of it. Nathan's attorney rose for cross-examination and spent 12 minutes attempting to establish that Sarah Novak had been coerced into recanting, that Diane Chu had offered her inducements, that her reversal was as manufactured as the defense was claiming her original testimony was. Sarah Novak answered each question with the flat, even persistence of someone who had already done the hardest thing and found the rest of it manageable by comparison. When it was done and Sarah Novak stepped down from the stand, she walked past the plaintiff's table without looking at Claire. But at the door of the courtroom she paused for a fraction of a second, not long enough to be a gesture, just long enough to be a choice. And then she walked out. Harold Briggs testified at 1:15. He was the same as he had been on the first day, compact, unhurried, the flat technical voice of a man who trusted, observed fact over interpretation. He confirmed the structural analysis. He confirmed that his findings had not been influenced by any external party. He confirmed that he had been unaware, until the previous evening, that his LLC had been acquired by a holding company connected to Nathan Cross, and he confirmed his reaction to that information in the exact, unembellished language he used for everything. "I was angry," he said. "I've spent 32 years in this work. The work means something. When someone tries to use it—" He stopped. His jaw moved once. "When someone buys the company that has my name on it without telling me so they can threaten to control what I say under oath, that is not something I can characterize in professional language." "How would you characterize it in unprofessional language?" Claire asked. He looked at her. The corner of his mouth moved in something that wasn't quite a smile. "Accurately," he said. After Briggs, Claire called Marcus Delaney for 20 minutes, clean, direct, the forensic accounting summary that laid the entire offshore structure out in a sequence that any literate adult could follow without legal training. Marcus was precise and unhurried, and his voice had the quality it always had in situations like this, the calm of a man who trusts numbers the way other people trust instinct. Then Claire stood and said, "Your Honor, the plaintiff rests." The room went quiet. Halverson looked at the defense table. "Counselor, any witnesses?" Nathan's attorney looked at Nathan. Nathan was looking at the table, the same flat wooden surface he had been looking at with increasing frequency over the past 4 days, as though it contained something he was trying to read. He looked at it for a long moment, and Claire watched his hands on the surface of it, the left one pressing flat, the fingers spreading slightly and then relaxing. And she understood, with the complete and final understanding that comes at the end of a long process of understanding, that he was not going to put anyone on the stand. There was no one left to put there. "The defense has no witnesses," his attorney said. Halverson did not recess for deliberation. She looked at the documents spread before her, the stack of authenticated exhibits that had accumulated over 4 days like the physical weight of everything Claire had carried for 18 months. And she looked at both tables, and she said, in the same flat voice she used for everything, the voice of a woman who had decided that the time for formality had passed, "I've heard enough." She reached for her pen. What followed was 47 minutes of judicial ruling that Claire would later recall not as a sequence of words, but as a series of physical sensations, the way the air in the room changed with each finding, the way the gallery behind her shifted and breathed, the way the light through the courtroom's narrow windows moved imperceptibly as the afternoon progressed. Halverson worked through the marital asset division first, methodically, finding that the concealed offshore assets constituted marital property under Connecticut law, and that the plaintiff was entitled to an equitable share of the full marital estate, including those assets, to be calculated by a court-appointed forensic accountant using the documentation Claire had provided. The number, when the accountant's formula was applied, was not 78 million. It was higher. Halverson moved to the structural fraud referral, formally directing the court clerk to transmit the Meridian Tower documentation to the Hartford Building Authority, the Connecticut Department of Consumer Protection, and the U.S. Attorney's Office. She noted for the record that construction on the tower would be halted pending a full independent structural review, and that the falsified certifications were being referred for criminal investigation. She addressed the forged signature, the fraudulent notarial acknowledgments, the fabricated liability transfer. Each finding was stated plainly and without elaboration, in the tone of someone reading a list of facts that have already been established and require only acknowledgement. And then she looked at Nathan Cross. "Mr. Cross," she said, "I've been a judge in this court for 19 years. I've presided over proceedings involving fraud, concealment, perjury, obstruction, and most of the other instruments through which people try to use the legal system to harm others. I want to note for the record that what has been documented in this proceeding over the past 4 days represents one of the most extensive and deliberate uses of those instruments that I have personally encountered." She paused. "I also want to note that it was uncovered, documented, authenticated, and presented to this court by a woman without legal representation, working with a forensic accountant and her own resources, after having had her intelligence, her competence, and her mental stability called into question by the very defense that assembled the fraud against her." She set down her pen. "The plaintiff is awarded full equitable division of the marital estate, including all identified concealed assets. The defendant is ordered to bear all costs of this proceeding. The divorce is granted. She looked at the clerk. The referrals will be transmitted this afternoon. She stood. The bailiff called the room to order, and then she was gone. Through the side door, back into the chambers where she had received Claire and Diane Chu the night before with a coffee mug and a sparse desk, and the expression of a woman who had looked at what was in front of her and chosen not to look away. The federal agents came through the main doors of the courthouse at 3:44. Claire was in the corridor, sitting on a bench outside the courtroom, her folders beside her, watching the afternoon light move on the marble floor when she heard the doors and looked up. There were 4 of them, and Diane Chu was with them, and they moved with the specific, unhurried efficiency of people executing something they have prepared carefully and are confident in. They went into the courtroom. She heard a few minutes later the sound of Nathan's voice. Not words, just the sound of it, brief and clipped, and for the first time in 15 years, not controlled. Then Diane's voice, flat and professional. Then nothing. She did not go back into the courtroom. She sat on the bench and listened to the building around her, the distant sound of the elevator, a phone ringing somewhere down the hall, the accumulated bureaucratic hum of a place where people spent their days trying to bring some order to the damage people did to each other. And she looked at her hands in her lap. They were still. They had been still for most of the past 4 days, and they were still now, which she noted the way she had noted the shaking in the women's restroom on the first morning, as information about what was happening inside her, as honest reporting from the body that had been in this with her the entire time. She heard, from inside the courtroom, the sound of a door, the side exit, the one that led to the back corridor and the prisoner transport access. It opened and closed once. She did not know exactly what she felt at that sound. She had thought about this moment for 18 months, had imagined it in various forms, in the kitchen at 2 in the morning, and in Marcus's conference room, and in the car on long drives when the case felt too large to hold, and she had expected to feel something large and definitive. Victory, relief. The particular fullness of a long effort completed. What she felt was quieter than that. It was the feeling of something that had been pressing against her for a very long time finally letting go, and the particular strangeness of the absence, the way you notice a sound you've been living with only when it stops. The marble floor held the afternoon light. Somewhere in the building, a phone rang and was answered. She picked up her folders, stood, walked toward the elevator. Lena Brooks was waiting outside on the courthouse steps in a better coat than she'd worn the day before. Heavier, dark wool, appropriate for November. She was standing with her hands in her pockets and her face in the pale afternoon light. And when Claire came through the doors, she looked up with the expression of someone who has been standing in uncertainty for a long time and has arrived finally at a particular kind of solid ground. They stood together on the steps for a moment without speaking. "It's done?" Lena said. "It's done." Lena looked at the street, the news vans still there, the reporters, the ordinary traffic of a Wednesday afternoon in Hartford moving past the courthouse as though nothing of particular significance had happened inside it today. She looked at it for a while with the expression of someone taking inventory. "I don't know what comes next," she said. Not as a problem. As a fact, she was reporting. "That's fine," Claire said. "Neither did I, 18 months ago." Lena looked at her. The light was going thin and cold the way it did in November, and her face in it was young and tired and possessed of the particular quality Claire had recognized in her from the first moment in the corridor. The quality of a person who has made a hard decision and is still standing. "I have a meeting tomorrow morning," Lena said, "with the Financial Crimes Division, about the accounts, the ones under the Stamford LLC. I know, Diane will take care of you." She said something similar. A pause. "She also said I might be called as a witness in the federal case." "You will be. Will you be there?" Claire thought about it, about federal courts and federal prosecutors, and the long process of what happened after a fraud case this size moved from civil to criminal, the years it would take to work through every layer of what Nathan had built. She thought about being called as a witness in those proceedings, sitting in other courtrooms in other buildings telling the same story she had told here, but with different procedures and different stakes. "Yes," she said, "I'll be there." Lena nodded once, and something in her face settled. Not relief exactly, but the specific lowering of attention that had been held for a long time. She pulled her coat tighter against the wind coming off the street. "Thank you," she said, "for what you—" She stopped, started again. "I know you didn't do this for me." "No," Claire said, "but you helped me finish it. That matters." They stood on the steps for another moment. Two women in November light outside a courthouse, and then Lena Brooks walked down the steps and turned left on the sidewalk and was absorbed into the ordinary afternoon, and Claire watched her go. She called her father from the parking garage. He was 78 and still lived in the same house in New Haven where she had grown up, and he picked up on the third ring the way he always did. Not the first ring, because he believed that picking up on the first ring communicated a lack of composure, and not after the fourth, because he believed that making people wait was a form of discourtesy. 3 rings. Every time. "Claire," he said. His voice was the same as it had always been, low, careful, the voice of a man who had spent 50 years listening to the things numbers said about people. "It's done, Dad." A pause. She could hear, in the background of the pause, the particular silence of his house, the clock in the hallway, the sound of the afternoon news he kept on low in the living room. She had grown up in that silence. She had learned in it to trust the evidence of careful observation over the noise of performance. "How do you feel?" he said. She thought about it honestly. She was standing in a parking garage with her folders under her arm and her back aching and her eyes dry from 4 days of insufficient sleep. And the cold of the concrete was coming through the soles of her shoes, and the afternoon light at the garage entrance was the thin, patient light of late November that didn't promise anything except the continuation of itself. "Like it costs something," she said. "Yes," he said. "That's what real things do." She stayed on the phone with him for another 10 minutes, not talking about the case, just talking, the way they had talked when she was a child and would sit at his desk while he worked, neither of them needing the other to perform anything, just existing in the same space and finding that sufficient. He told her about a book he was reading. She told him she would come to New Haven on Sunday. He said he would make soup, which was his way of saying he was glad she was coming, and which she understood perfectly. She drove home in the dark. Bachet. 3 months later, the construction halt on Meridian Tower became permanent. The Hartford Building Authority, operating on Harold Briggs's structural analysis and the findings of 2 independent engineering firms commissioned in the aftermath of the court referral, determined that the foundation was irremediably compromised, that the cost of remediation exceeded the value of the structure, and that demolition was the only viable course. The announcement was made on a Thursday morning, and Claire read it at her kitchen table with a second cup of coffee, and the number she thought about was 600 to 800, which was what Harold Briggs had said when she asked him, in plain language, what the risk meant. 600 to 800 individuals. The number sat in her mind the way numbers had been sitting in her mind for 18 months, not as an abstraction, but as the specific weight of a specific fact about the specific world that continued to exist outside the courtroom and the kitchen table and the parking garage and the cold November steps. Nathan Cross was indicted on 17 federal counts in the week after the divorce ruling. The indictment included wire fraud, bank fraud, bribery of public officials, obstruction of justice, and conspiracy. The architecture of what he had built, laid out in the language of criminal law, each charge a beam removed from a structure that had appeared solid for a very long time and was now revealed as the hollow thing it had always been. His attorneys filed for bail. It was granted at an amount that reflected the court's assessment of his resources, which was to say it was high, and which he paid, and which meant he was not yet in a cell, but was also not free in any way that the word had previously meant for Nathan Cross. Gerald Voss surrendered his law license in a quiet administrative proceeding that was reported on page 14 of the Hartford Courant, and which Claire read with the specific, flat feeling she had learned to have about outcomes that were correct but not satisfying, the feeling of justice operating at its normal institutional temperature rather than at the dramatic heat of a courtroom. Sarah Novak left Voss, Klein, and Hartley the same week the story broke. Claire did not know where she went and did not look for that information. She had thought more than once about the 12 days in August, about a young woman organizing folders in a spare bedroom, watching a case take shape, making a choice under pressure that she later unmade under different pressure. She had thought about the cost of that, what it said about the size of the mistake you were willing to make when you were 24 and afraid, and someone older and more powerful than you was framing the choice. She did not forgive it easily, but she understood it, which was its own kind of resolution. Angela Voss. Angela Voss. She did not hear from after the proceedings. She had thought about reaching out, a note, something, and had decided against it. Angela Voss had done what she'd done for her own reasons, out of her own exhaustion and her own reckoning, and those reasons belonged to her. Claire had learned, in 18 months of careful work, the difference between gratitude and ownership, and she kept the distinction clean. What? 6 months after the divorce was finalized, Claire Rowan filed the paperwork to reactivate her law license. The process took 4 months. The bar review, the character and fitness assessment, the documentation of the intervening 15 years, and she completed it the way she had completed everything in the past 2 years. Methodically, without drama, paying attention to the sequence. Her former law school classmate Diane Chu wrote her a letter of recommendation that was 2 pages long and which Claire did not read until after it had been submitted because she had asked Diane to say what she actually thought and didn't want to know what that was until it no longer needed to change anything. She read it afterward, alone in her apartment, on a Tuesday evening in autumn. It was 2 pages long. She read it twice. She folded it and put it in the second drawer of the kitchen table, the same drawer that had held the sealed envelope, the document she had saved for the moment Nathan believed he still had a way out. The drawer was otherwise empty now. All the forensic accounting reports and flash drives and manila folders were in storage, part of the federal evidence record. The kitchen table was just a kitchen table. She sat at it for a while after reading the letter, with a glass of water and the window showing the evening city and the specific quiet of an apartment that had been a workspace for a long time and was becoming, slowly, something else. A place she lived in. A place that didn't vibrate, every surface, with the accumulated tension of a case being built. She thought about her father's words. That's what real things do. She thought about the texture of the past 2 years. The early Tuesday morning with the laptop and the $40,000 transfer and the door opening into the room she hadn't known she'd been locked out of. The months of kitchen table work, the 4 days in the courthouse, the women's restroom and the cold water and the face in the mirror that she hadn't recognized at first and then had. She was not the same person who had sat at this table in November 2 years ago. She understood that with the clarity she brought to everything now, the same clarity she had learned from her father and from Marcus Delaney and from the specific discipline of building a case that had to be true because the alternative was someone else's truth, and someone else's truth was going to put her name on a building that could kill 800 people. She was not the same person. She was also, in the ways that mattered, exactly herself. The office she eventually rented was on the 6th floor of a building on Chapel Street in New Haven, 12 blocks from her father's house, with windows that faced west and caught the afternoon light the way she had hoped they would when she first walked through the space on a gray October morning with a real estate agent who kept apologizing for the view. "I like the view," she'd said. The agent had looked at her. "It's mostly the old industrial district." "I know," she said. The sign outside read Rowan Legal Services. Below that, in smaller letters, financial fraud and economic abuse. She had thought about the wording for several weeks and had arrived at those specific words because they said exactly what the work was and who it was for. People who had been made to feel that the fraud being committed against them was their own fault, their own failure to pay attention, their own weakness for trusting someone who turned out to be keeping a separate set of books. People who had been standing next to their greatest weapon for years without knowing it. Lena Brooks came to the office on the day it opened, which was a Thursday in December, cold and clear, the kind of winter day that was honest about what it was without being unkind about it. She was 7 months along by then, moving with the particular careful deliberateness of late pregnancy, and she had brought coffee and 2 cups from the place on the corner and had not called ahead, which was exactly the kind of thing Claire was learning to appreciate about her. The directness, the absence of performance. They sat in the new office, which smelled of fresh paint, and the particular smell of boxes recently unpacked, and drank the coffee and looked at the view of the industrial district, which was exactly what the real estate agent had said it was. Old warehouses, a water tower, the winter sky above it all. Nathan's trial starts in March, Lena said, not as a question. March 15th. You'll be there? Yes. Lena turned the cup in her hands. She was quiet for a moment, not the uncomfortable quiet of someone who doesn't know what to say, but the settled quiet of someone who has said the important things and is comfortable with what remains. He sent a letter, she said, through his attorneys, to me. She looked at the window. I didn't read it. I wanted to know if I should. Claire thought about that. About the letters that arrived in certain kinds of cases, the ones sent not out of remorse but out of the instinct of a certain kind of person to keep reaching for leverage even when all the instruments have been taken. She thought about Nathan at the bottom of the courthouse steps. You don't know what you're doing. She thought about the text message. You should stop now. She thought about the way he had said her name, just her name, stripped of everything, and the things she had seen in his face, the small and human thing beneath the performance. She thought about whether that small and human thing was enough to make the letter worth reading. No, she said. You don't have to read it. Lena nodded once, set the cup down. Okay. They sat with that. The afternoon light through the west windows was thin and pale and honest, the winter light that came without pretense and asked nothing of the room except to be in it for a while. Below on Chapel Street, a delivery truck moved slowly past. Someone walked a dog. The ordinary world continued at its ordinary pace, without reference to what had happened in a courthouse 12 blocks away, or 300 miles away, or in the kitchen of an apartment on a Tuesday evening 2 years ago. Claire looked at the sign on her office door, at the client chair on the other side of the desk that was, for now, empty and would not always be. She thought about her father saying, "Watch what people do with their hands." She thought about the first thread and the room it had opened. She looked at the winter light, and she breathed, and she let the story end here, at the beginning of the next thing, in an office that smelled of fresh paint and possibility and the specific, unglamorous, necessary work of helping people retrieve what had been taken from them, not because the work was easy or the victories were clean, but because she had learned, in the way that only doing a thing teaches you, that she was exactly the person for it, and that knowing that was, itself, enough.